E. He further testified that if the driver was too scared to drive the vehicle, he would drive his vehicle. He was attempting to drive the vehicle when the complainant continued shenanigans. He then went back to the complainant and pushed him and said, "Leave my car." He considered that the funeral was a state funeral and that both the army and the police are in charge, and therefore no one will dare undermine such authority. Or accused one maintained that his vehicle was not the last vehicle to enter the cemetery. There is a lead in front and there is a car that blocks people from joining the convoy. So our car was not the last one. See photo 6 at exhibit 4, which is inconsistent with his testimony of the accused. There is no vehicles or motor vehicles before or after the accused vehicle. During the viewing of the video footage, the accused confirms he was pushing the complainant to remove him from his car so that the car could go in because he had no justifiable reasons to stop the car. T. The vehicle was authorized to enter. I did not violate any law. I wanted to bury my mother, and if that is a crime I committed, I am proud to have committed that crime. Send me to jail if you want. The following was elicited from him during cross-examination 1. He was in the vehicle with accused 2 and 2 protectors. 2. He confirms that the complainant spoke to the driver. 3. He confirmed having heard the conversation between the driver and the complainant. 4. He confirmed that the complainant requested the accreditation from the driver. The driver showed him the accreditation on his chest and the vehicle accreditation. 5. He confirmed that driver indicated that he was driving accused 1. 6. He further testified that the driver pointed to the vehicle accreditation. 7. On exhibit 4.6, he confirmed that one cannot see any writing on it. 8. He confirmed that the complainant never spoke to him while in the vehicle. 9. He testified that he got out of the vehicle when the complainant blocked the vehicle. He wanted the complainant to recognize him. He then asked the complainant what he is doing. 10. He stated that the complainant started speaking Afrikaans and he realized that there was no cooperation. He then moved to the driver's side to drive his vehicle. 11. He testified that bypassers pushed the complainant. He then came back from the driver's side and started to push the complainant. 12. He confirmed that while he was pushing the complainant never reacted and behaved as if he was possessed. 13. He confirmed that the issue of pushing the complainant was in dispute. He confirmed that the issue of pushing the complainant was not in dispute. 14. He further testified that while he was pushing the complainant kept on charging towards him. 15. He testified that the aim of the complainant was to stand in front of the car. 16. The accused confirmed that the complainant never pushed him. 17. The testimony was that charging was not being friendly. 18. He testified that when the protector and accused arrived on the scene and the other people and saw that they were pushing him, the complainant started moving backwards, and that is when they pushed him to the side. 19. He denied that the complainant called the VOC. He testified that you either have a right or not to enter. He further testified contacting the VOC was another defense mechanism that should not be accepted. 20. He further testified that his life was not in danger. Our dignity was in danger. Our humiliation was going to be the order of the day. Our enemies will derive pleasure out of the fact that we are denied the opportunity to bury our mother. That was in danger. Our ability to have closure with the late Winnie Mandela was in danger. The second witness called by the defense was accused to Mbuyiseni Ndlozi. He testified earlier the following. He testified that on 14 April 2018, he was the spokesman of the EFF. B. My duties was to travel with the president of the EFF, being accused number 1. C. He went with accused 1 to the stadium for the memorial, and the vehicle went through the necessary checkpoints. The vehicle was parked in the basement. D. After the memorial at the stadium, they joined the convoy to the cemetery. E. They arrived at the cemetery, and at the gate they were stopped. F. He was not clear as to why they were stopped, and the driver indicated that there was a concern about accreditation. It looked like we were being refused entry. G. Accused 1 got out and engaged the police officer concerned. The police officer was not cooperating and blocked the vehicle with his arms and body. He then went out to also engage the police officer, and he was not listening. H, the complainant kept on saying, we were not allowed entry. He tried to pull him, and the police officer resisted without doing much. I, accused to pulling the complainant had no effect on the complainant, but had an effect on him. J, they tried to remove him from the vehicle, and he kept coming back using his body. K, accused to idea was to push him as far out as possible so that he would enter. L, we had a right to be there, and then a lot of people started intervening who were standing on the side, including the police officers, and they were talking to us and not to him at first. M, we were requested nicely to go into our car and proceeded to enter, which we did. N, accused to testify that Staff Sergeant Mapisa did not stop them, and the first person who stopped them was the complainant. O, he maintained that the complainant indicated that they were not allowed to enter. P, he maintained that the vehicle had a permit and went through multiple checks. He also stated that all the people in the vehicle had credentials. Q, he felt fundamentally denied our freedom of movement and also the dignity to mourn. It was a fundamental humiliation. R, he also testified that he was not going to comply with the instructions from the complainant, as it was his right to enter the cemetery. Not even the complainant had a right to interfere with his dignity. The following was elicited from him during cross-examination. 1, he was not a speaker at the stadium, and neither was his name mentioned on the program. 2, his name was also not mentioned in Exhibit E. 3, he confirmed that accused 1 got out of the vehicle first. 4, thereafter the protector got out. He then got out of the vehicle and approached the complainant, as he was not cooperating with accused 1. He then approached the complainant and said, "What are you doing? We have all the rights to be there." Bracket close. The complainant responded by saying no, and they were not allowed to enter, and then he pulled the complainant. 5, he was the first person to be with the complainant on the other side, as he used a different door. 6, he confirmed that he pulled the complainant and grabbed him by his hand and tried to remove him from the car in a pulling position. 7, he then pushed him in the opposite direction to remove him from the car. He used both hands to push him, and he kept coming back. 8, he managed to push this mountain of a man by 3 steps. 9, accused 1 came at a much later time after the strangers pushed him. 10, his entire objective was to move a physical mountain of a man who was refusing him entry. His focus was on the complainant, as the complainant was the violator, provocateur, and was the obstacle. 11, he confirmed that their vehicle came after the 2 X5 BMWs. 12, he confirmed that both accused pushed him against a wall so that he does not come back. 13, he testified that his life was in danger, as his dignity was his life. It should be noted from the outset that during the testimony of both accused, aspects was raised in their testimony regarding the assault on the day in question, which was not put to the complainant to comment thereon. Exhibit E, Zanzi Mandela. The exhibit was handed in by the parties consenting thereto. It should be noted that the aforementioned exhibit was used for purpose of settling the matter through alternative dispute resolution, which did not materialize. This witness only heard about the incident much later and solely deposed this statement to persuade the state to decline to prosecute the accused. 13, discussion. It is the state's submission that the aforementioned witness testimony needs to be broken down in the different categories applicable in law. 13.1, corroboration. Corroboration is evidentiary material outside the evidence corroborated. It must come from an independent source. R versus Manana, 1931 AD 386, and R versus Rose, 1937 AD 467, and S versus Burke, 1976, brackets 4 SA 857, bracket A. Properties of corroboration. Sorry, Your Worship, may I just have water?
Yes, Your Worship.
Thank you, Your Worship. Romans 1, it must be admissible. R versus Huabe, 1939, AD 25. Romans 2 can be provided by any means, or S versus Van As 1976, brackets 2, SAPH H205, bracket A, S versus Chabalala and 2 others, 1977, bracket 2, PH 201, bracket A. Romans 3, corroboration must come from a source outside the fact that needs to be corroborated. R versus Chris in 1914, AC 45, AC 545, S is Rousseau 1994, bracket 1, SA SV 626, bracket okay, bracket closed. 4, Romans 4. It must be on a material aspect, R versus P 1957, bracket 3, SA 444, bracket A, bracket closed, SA Artman 1968, bracket 3, SA 48, bracket A. Romans 5, corroboration does not alter the evidential burden. S versus Kearney 1964, bracket 2, SA 495, bracket A. R versus Ndlovu 1983, bracket 1983, bracket 4, SA 507, bracket ZS. Romans 6. Corroboration can also be provided by the opposing party, S versus W 1963, bracket 3, SA 516A, S versus Rousseau 1994, 1, bracket 1, SA SV 6260, bracket okay. Corroboration by the state witness as well as the accused testimony on material aspects of the state's case. 1. It was never in dispute that the complainant was in charge of the gate at the cemetery. This was confirmed by the last state witness, Staff Sergeant Mapisa. It was never in dispute that the accused were traveling in a black Mercedes Benz. This was corroborated by the testimony of the complainant, Staff Sergeant Mapisa. The video footage as well as the testimony of both accused. 3. It was not in dispute that accused 1 was a speaker at the memorial at the stadium. This was corroborated by Exhibit A as well, testimony of both accused. 4. It was not in dispute that the complainant stopped the vehicle in which the 2 accused traveled. The accused version corroborates the testimony of the complainant. 5. Exhibit 3 was admitted by consent and ruled admissible. Exhibit E was also admitted as an exhibit by consent between the parties. 7. Exhibit 1 to 4 was also admitted as an exhibit by consent between the parties. Number 8. It is common cause that the complainant did not any stage assault the 2 accused before court. This was corroborated by the video footage as well as the testimony of the 2 accused before court. Exhibit 3, the video footage. The following is noted as per the contents of the video footage. 1. At 15:49, 05 seconds, an altercation between a gentleman having a red umbrella and the complainant. The complainant is being pushed by this unknown gentleman. 2. At 15:49, 10 seconds, accused 1 approaches the complainant and this unknown person with a red umbrella. He is being pushed away from the vehicle. 3. At 15:49, 18 seconds, accused 1 pushes the complainant. There is no retaliation from the complainant. The complainant's back is facing accused 1, going towards the wall of the cemetery. 4. At 15:49, 22 seconds, accused 1 pushes the complainant and immediately thereafter accused 2 arrives and assists accused 1 in pushing the complainant towards the wall of the cemetery entrance. At that stage, there is still no retaliation from the complainant. 5. At 15:49 and 50 seconds, the unknown person with the red umbrella comes between accused 1 and 2 to avoid the complainant being assaulted further. Throughout this incident, the complainant in no way retaliates against any of the 3 people whom are assaulting him. 13.2 Contradictions. The state submits that there are contradictions on record in respect of the facts surrounding the issue of statements taken in the docket. However, there is no material contradiction insofar as the assault took place on the day in question on the complainant. The fact that the assault on the complainant was never disputed. The contradictions so far as the facts surrounding the issue is moot. It should also be noted that the witness, Mr. Krimble, testified that the original docket went missing and thus the initial docket had to be reconstructed. It is absurd to expect a witness to furnish precisely the same account in evidence as given in his or her statement. Reyners, 1998, brackets 2 SACR 432, brackets SE. In Malavidiso versus the state, 2003, bracket 1 SACR 583, bracket SCA, pages 593 J to 594A to G, bracket close. Discrepancies in statement caused by one sentence only could be interpreted in one or two ways. It must be read in the context of the whole statement, held that the court must handle discrepancy between different versions of the same witnesses with circumspection. First, the court must ascertain what the witness meant to say in order to determine whether there was a discrepancy and the extent of the discrepancy. The court must take into account the following: the fact that a statement to the police was not subjected to cross-examination, language and cultural differences between the witness and the person who took the statement, and the fact that the police did not require any explanation of a statement. Secondly, not every error by or discrepancy in the statement affects the witness' credibility. Thirdly, the different versions must be evaluated holistically. This evaluation includes the circumstances in which the versions were given, reasons for the discrepancies, the effect of the discrepancies on the witness' credibility, and whether the witness had sufficient opportunity to explain the discrepancies. Lastly, the witness' statement to the police must be weighed up against the witness' view of okay evidence. Evaluation of the facts in issue. It is the state's submission that the first issue wherein the court has to make a finding is whether the defense of justification is a valid defense based on the evidence on record. The main question that needs to be decided on is whether the conduct of the complainant was of such a nature that the two accused before court had lawful right to assault him as an act of necessity. The state will now refer to the various encounters that the complainant had on the day question with members of the public as well as mourners who wanted to enter the cemetery on the day in question. First incident. The first incident happened where a lady came to the four-way cemetery. She was coming from England and wanted to visit her parents' gravesite. She was then informed that the whole area was barricaded for the funeral of late Winnie Mandela. She wanted to speak to someone in charge of the cemetery. The complainant came to the gate and explained to the lady what is happening at the cemetery, and he also called Miss Erasmus to explain the situation as per the transcript dated 28 October 2020 on page 8. Second incident. A man from Rapopo came to the four-way cemetery to visit the family gravesite. The complainant came and explained what was happening at the cemetery, and he also contacted Ms. Erasmus to further explain to this gentleman. Transcript dated 28 October 2020 on page 8 and 9. Third incident. An SUV came followed by another vehicle. They wanted to visit the gravesite of their loved ones. Again, the complainant called Ms. Erasmus, who came and explained what is happening at the cemetery. Transcript dated 28 October 2020 on page 9. Fourth incident. Later in the afternoon, two ladies with accreditation around their necks to enter the cemetery. The complainant informed them that no one is allowed to enter the cemetery before the family. One of the ladies made a call, and the person on the other side of the call was Manda Mandela. Manda Mandela asked complainant, what is the problem? Why can't the ladies enter the cemetery? The complainant explained to Mandela that no one is allowed within the vicinity or enter the cemetery before the family. Mandela then told complainant that is correct and would like to speak to the lady again. The lady then apologized to the complainant and moved down the street. Transcript stated 28 October 2020, page 9, 10, and 11. Fifth incident. This incident is before the Honorable Court. The state would like to draw the court's attention to the following. One, in the three incidents above, the members of the public, mourners, engaged into conversation with the complainant to understand why they could not enter the cemetery on the day in question. The complainant sought to use the services of Ms. Erasmus to supplement the reason why people were not entitled to enter the cemetery on the day in question. Two, in the incident before court, the complainant testified that he stopped the vehicle as the vehicle came after the convoy, and he testified that he would stop the said vehicle as it was not part of the convoy. He wanted to get the necessary authorization to allow them in. However, the two accused before court never engaged with him to resolve the issue. They elected to take the law into their own hands. The two accused, without any imminent danger or threat, assaulted the complainant. 4. In order to ascertain if the defense of justification is valid, the court has to look at the evidence in totality, and it is the state's submission that the conduct of the complainant on the day in question did not warrant an attack on him. 5. In order for the defense of justification to succeed, the court has to evaluate evidence against the that be required for justification to be successful. 5.1. Legal interests endangered. Danger of death or serious bodily injury may justify an act done in circumstance of necessity. This is not applicable to the evidence before court, as the accused's life was not in danger. 5.2. Threat, commence, or imminent. The threat of harm must have commenced or be imminent. There is no evidence on record to show that there was a threat of any harm or that harm was imminent on the accused. 5.3. Threat not caused by accused's fault. Since a person cannot rely upon his or her own default to escape from liability, the necessity should not be a result of the accused's own fault. The complainant on the day in question was exercising his duty assigned to him and could only override the standard instructions after obtaining the necessary permission from the VAR. The accused initiated the assault on the complainant that interfered with the duties of the complainant. The aforementioned unlawful assault by the accused on the complainant prohibited the complainant from obtaining the authorization from VAR. The complainant did not retaliate at any stage during the incident. Accused 1 stated in his testimony that he would not reason with anyone who will stop him from burying his mother. Transcript dated 3rd of June 2022, page 6. 5.4. Necessary for the accused to avert the danger. This requirement does not mean that the accused act must be necessary in that there is literally no option but to perform it. For in this sense, there is no such thing as necessity. The accused must do everything possible to avoid the compelling force. The state submits that the accused engaged the complainant in a different manner, or alternatively engaged the complainant's superiors by way of communication. The unlawful assault on the complainant could have been avoided. 5.5. Reasonable means to avoid the danger. Not only must it be necessary for the accused to avert the threatened harm, but also the means he or she uses for this purpose must be reasonable in the circumstances. This is a crucial issue that the court has to take a determination on. To satisfy this requirement, the accused proceed, Your Worship.
Yes, you may proceed.
Just
before you do, it was announced that cell phones needs to be off. The court have allowed the media to be present, to record, and most probably to use any other device to record. But the proceedings should not be disturbed by anybody, including the media. So if you have your cell phone on, see to it that it's on silent and it does not disturb the proceedings. The next cell phone that will disturb the proceedings, the court will require the police officers to ask that person to leave the courtroom because it is disruptive. The prosecutor can now not read into the record her heads of arguments. Thank you, Ms. Hart. You may proceed.
Thank you, Worship. I'll just repeat, Your Worship, this is the crucial issue that the court has to make a determination on. To satisfy this requirement, the accused must do no more harm than is necessary to avoid the danger. The state submits that assault on the complainant was not the only option available to them at the time of the incident, and had their conduct been different on the day in question, it should be, in Your Worship, through meaningful conversation, this incident could have been avoided. The complainant under examination in chief illustrated to this honorable court that in 4 different occasions feasible solutions can be acquired through meaningful dialogue with members as mentioned above. Accused 1 acknowledged in his testimony that at a state funeral the army and the police are in charge and therefore no one will dare undermine such authority. The conduct of both accused clearly went against the grain of the above testimony. Summation. The state submits that the attack on the complainant was goal-driven and nothing was given to stop the two, and nothing was going to stop the 2 accused from entering the cemetery. The following testimony of the accused is used in support thereof. A. Late Zandi and Ambassador Zenani took him outside and requested that he give a speech on the day of her burial, and they do not want him to speak at the memorial. B. Both the state and the ANC are refusing that he speaks, and that they do not want him to speak there, as it was a state funeral. C. Colonel Fender started speaking of Afrikaans, and that is when he got agitated. D. It was an emotional day for him. Any attempt to stop him from burying his mother will be a humiliation and a violation of his dignity as an individual. I was not going to reason with anyone who was going to stop me from burying my mother. I did not violate any law. I wanted to bury my mother, and if that is a crime I committed, I am proud to have committed that crime. Send me to jail if you want. He further testified that his life was not in danger. Our dignity was in danger. Our humiliation was going to be the order of the day. Our enemies will derive pleasure out of the fact that we are denied the opportunity to bury our mother. That was in danger. Our ability to have closure with the late Winnie Mandela was in danger. Accused 2, he also testified he was not going to comply with instructions from the complainant as it was his right to enter the cemetery. Not even the complainant had a right to interfere with his dignity. B, he testified that his life was in danger as his dignity was his life. The video footage shows that the 2 accused assaulted the complainant without any imminent threat towards any of the accused. The state submits that the accused was not open to reason with any person on the day of the incident, as it is evident from the testimony, and that they would have disobeyed the laws of the Republic of South Africa to enter the cemetery, instead of using the laws to acquire the desired outcome. The accused openly testified in court that they would have disregarded the laws of the Republic of South Africa to enter the cemetery. It is therefore submitted that the defense of justification cannot stand before this honorable court. It is the state's submission that the state has proven its case beyond a reasonable doubt, and that the accused should be convicted as charged. Dated Randburg on the 1st of August 22, signed by myself, Your Worship. Please support.
Thank you, Ms. Hyde. The state's heads of arguments will be marked as Exhibit B.
Sorry, Your Worship, exhibit?
B. So it is.
Thank you, Worship. Worship, as previously recorded, we were required to file heads of argument on the 19th of August and complied with Your Worship's directive in this regard. I beg leave to read those heads onto the record. May I proceed?
Yes, you may do so.
Thank you, Worship. They are held in the Magistrates Court for the District of Johannesburg, held at Randburg, case number 3/4067/2019, in the matter between the state and Julius Malema, accused 1, Mbuyiseni Ndlozi, accused 2. Heads of argument on behalf of accused 1 and 2. Subheading the charge. 1. Both accused are arraigned on one count of common assault. It is alleged that upon or about 14 April 2018 in at or near Fourways Memorial Park in the district of Johannesburg North, they did unlawfully and intentionally assault Johannes Jacobus Venter by pushing him. Subheading the plea. 2. Both accused pleaded not guilty. The base upon which they did so was one of justification. Both accused believed that they were entitled to enter the cemetery for a burial ceremony and that the obstruction of them was illegal and unjustified. In the circumstances, they lacked mens rea because they believed at the very least that they were entitled to enter the cemetery for a burial. 3. There was also a political agenda. Both accused reached out to the complainant by process of Ubuntu that was rejected by AfriForum. There was a political agenda between AfriForum and the EFF. The references to the transcripts are there, Your Worship, with the footnotes. Subheading the trial. 4. During the trial, the state led the evidence of 7 witnesses and showed a video depicting the event. 5. Both accused applied for the discharge at the end of the state's case. This was refused in a detailed judgment by the presiding magistrate. Both accused then testified. Subheading judgment refusing section 174 discharge. 6. The presiding magistrate had regard to the evidence led at the stage and held inter alia as follows. Sub 1. The state's case has discrepancies, specifically with reference to Mr. Venter's and Staff Sergeant Mapisa's evidence relating to the charge of assault. Sub 2. Thus, when he looked at the direct evidence in regard to the assault, he agreed that Mr. Venter's evidence, when challenged whether the accused may enter the cemetery with their vehicle, went from nobody other than the family and the president, as well as the deputy president, who were allowed to enter in vehicles, to only accredited vehicles with a permit could enter, to the accused vehicle had not been part of the convoy, to the accused vehicle had no escort, to even if the vehicle had a permit, he would not have allowed it to enter, to he contacted the venue operations center to get permission to allow the vehicle in, and that General Zulu gave or did not give permission. These are all the different versions that he put before the court, Your Worship, and Your Worship noted them on the ruling that we've referred to with the citation, Your Worship, at page 114 to page 115. Sub 3. The evidence by the state witnesses relating to whether the accused were allowed to go into the cemetery with the vehicle is not clear, nor convincing in any manner. Sub 4, one cannot take oral evidence in isolation of the written statements of the witnesses. It does not speak with one voice. It creates different scenarios and has an effect on the credibility. What the court must accept is the correct version. Sub 5, it still is unclear what should be the first and last vehicle to enter the cemetery. On the video, there is a marked vehicles with blue lights on, and unmarked cars as indicated by the witnesses. Other vehicles were rented and would therefore not be marked at all. No list was given to him of all vehicles that should be permitted to enter. Sub 6. The version of Colonel Fenter relating to how the convoy was compiled kept on changing as mentioned above. Therefore, it is highly debatable on how these operations were deployed for the safety of the President, Ministers, Deputy Presidents, as well as heads and ex-heads of state. Sub 7. Specifically, if you are stopped and have no right to enter but later also have entered, this then in return will defeat the whole purpose of regulating entry with safety in mind. Sub 8. Approximately 4 years have passed, yet it is still not unequivocally clear whether the accused had the right to enter or not with their vehicle. Sub 9. The issue was also attempted to be rectified by reference to multiple statements having been deposed to by Colonel Fenter but without success. Sub 10. Further, these discrepancies go to the trust of entry into the cemetery and not directly to the definition of elements of the offence of assault. Sub 11. He thus refrained from making a credibility finding at that stage. Sub 12. The slightest touch of a human of the body of another person with intent could be considered as an assault. Sub 13. This leads to the dispute between the state and the defence, where an accused has acted in the form of justification which will exclude unlawful and intention to commit the offence of assault. The person can act in private defence in protection of his life or bodily integrity, but in principle there is no reason not to accept that a person may act in private defence to protect other legal interests. Sub 14. The courts have accordingly recognised private defence in protection of property, dignity, freedom of movement and prevention from unlawful arrest and so forth. Sub 15. What is then seen on the video, which is Exhibit 3, is prima facie proof of an assault on the complainant. Mr. Fenter's evidence is also clear that he maintained that he was assaulted by the actions of both accused. The justification of the assault, which is in dispute, must be tested. Subheading, relevant evidence. 7. Premised upon this ruling, and in order to decide whether the assault was justified, the evidence of only 3 state witnesses and both of the accused becomes relevant. We apologize for the repetition in this regard, but it does bear reference on this issue and needs to be set out. These are as follows. Sub 1. The complainant, Colonel Johannes Jacobus Venter, testified inter alia as follows. Sub 1. He was based at the South African Police Service Presidential Protection Service Head Office in Pretoria. Sub 2. He had 36 years service, of which 6 years were in that unit. Sub 3. He was a planning officer responsible for the protection of the President, the Deputy President, heads of state, former heads of state, and former heads of state of the Republic. Sub 4. On 14 April 2018 at approximately 15:40, he had been on duty at Fourways Memorial Cemetery in uniform at the main entrance with 2 other women. Sub 5. The hearse had arrived, followed by the President, the Deputy President, heads of state, and previous heads of state. Thereafter, a Mercedes-Benz Vito came to the gate. Sub 6. He did not, quote, see any visible vehicle permit, close quote. Sub 7. Normally the permit is placed on the left-hand side of the vehicle on the window. Sub 8. Such a vehicle permit, quote, means it gives you permission to enter the said premises, close quote. Sub 9. He stopped the vehicle and spoke to the driver, informed him that the leader of the EFF, namely Mr. Malema, was inside the vehicle. He then saw Mr. Malema inside the vehicle. He greeted him and informed him that the vehicle cannot enter, they had to walk inside. Sub 10. Mr. Malema informed him that they would not walk inside, they will drive in. Sub 11. He then said that he will first get permission from the Venue Operations Center, VOC, then he tried to contact the VOC. Sub 12. He was then pushed from the right-hand side but could not say who had pushed him. Sub 13. He then saw Mr. Malema jumping out of the vehicle. Sub 14. Mr. Malema said, quote, no white man will stop me, close quote. He was then pushed a second time from his back but did not see who it was. Sub 15. He then moved back to the front part of the vehicle where he was pushed by both of the accused. Sub 16. The second time he was pushed so hard that he lost his balance and fell against the guardhouse. Sub 17. At that stage, General Zulu came closer to him and told him, quote, leave, close quote. Sub 18, at some stage the accused got back into the vehicle and drove into the cemetery. He had no idea who had given it permission to do so, as neither he nor General Zulu had given such permission. Sub 19, General Zulu is his senior and works as a different department of the SAPS. Sub 20, the vehicle was stopped because the whole convoy was already inside the premises. It came afterwards and had no escort. Sub 21, he had been instructed by Lieutenant Colonel Mutaung that only the immediate family and the president could enter the cemetery. The rest of the people would remain at the stadium where big screens had been erected to televise the funeral proceedings. Sub 22, he then utilized the map to indicate where the allocated parking was and the VOC. Sub 23, the accused had personal permits around their necks, but he had not seen a visible permit on the vehicle. Even if he had seen such a visible permit, he would have stopped the vehicle because it was not part of the convoy. Sub 24, the cars which had permits to enter the cemetery were in the convoy of the Mandela family, the President of the Republic of South Africa, followed by the Deputy President, followed by heads of state. Sub 25, he was then shown video footage and commented on what he saw. 7.2, during cross-examination he conceded that, Sub 1, he had been told over the radio when the convoy left the stadium, but was unaware of the time because he did not look at his watch. Sub 2, he described the arrival as depicted on the video as not being haphazard, but in his view it was orderly. Sub 3, the funeral program which was then shown to him had not previously been shared with him. This was subsequently admitted as Exhibit A. Sub 4, item 17 on the funeral program was a tribute to Mrs. Winnie Madikizela Mandela. Sub 5, despite the official program indicating that accused 1, Mr. Julius Malema, was instrumental in those proceedings, he had never received at any stage such a program. Sub 6, the Mercedes vehicle that the accused were in was accredited, but he maintained that the accreditation was for Orlando Stadium because he had been informed by Lieutenant Colonel Mutaung on 13 April that only the family and the president will come to the cemetery or graveside. Sub 7, it was then put to him that this was not true as the video had shown other people arriving. He then responded that on the day of the funeral, when the convoy left the stadium, they were informed that the Deputy President and the heads of state were part of the convoy. Sub 8, nevertheless, he did not know how many vehicles made up the convoy. Sub 9, he considered that most of the roads on the route to the cemetery had been closed that day. Sub 10, consequently, it was impossible for any other vehicle to just join the convoy. Sub 11, he had seen the black Vito Mercedes vehicle but did not see any visible vehicle permit. Quote, and even though they had the vehicle permit, I, being he, would have stopped them. Close quote. Sub 12, it was then put to him that the permit was clearly visible. In response, he said that he never saw it. Sub 13, it was further put to him that on the late Zinzi Mandela's version, Mr. Malema was part of the Mandela family. His response to this was that, quote, if Mr. Malema was part of the family, he would have driven with the family in the vehicle, in the car, or his vehicle would have made part of their convoy. Close quote. Sub 14, it was then put to him that he had been part of their convoy. He denied this. Sub 15, he then conceded that on his version, the convoy was very important, but there was no mention of the convoy by him in his statement. His explanation was that he had given a short version of what had taken place because at that stage he was still in shock. Sub 16, nevertheless, having seen the video a week later and having been given an opportunity to make a follow-up statement, with the assistance of his Solidarity Union and their attorneys, he still did not mention the convoy. Sub 17, he had only seen 3 people in the vehicle, but it was put to him that there were 4. Sub 18, his statement in paragraph 4 contained the express words, quote, I then explained to the people of the vehicle that they are not allowed to get inside the cemetery according to the instructions I received, close quote. Sub 19, he then tried to explain that the reference to the people of the vehicle meant the vehicle, but was forced to concede that this statement states what it states. Sub 20, his own statement further states that he had tried to contact the VOC to verify if he can allow, quote, them, close quote, inside, which clearly also did not refer to a vehicle. Sub 21, this was so despite the fact that on his own version, they had worn accreditation around their necks. Sub 22. Additionally, his statement at paragraph 5 expressly states, quote, "Then General Zulu came and informed me that it was fine, they can get inside the cemetery," close quote. Sub 23, it was then put to him that this contradicted his version that they had never been given permission to enter the cemetery. Sub 24, thereafter, as depicted in the video, the vehicle entered the premises without any hindrance. Sub 25, significantly, he then said that he could not speak on behalf of General Zulu. Sub 26, despite the accused both having accreditation, he saw no need to apologize to them for preventing them from entering the cemetery. Sub 27, he had in fact established from General Sam Sitlebani that they were entitled to enter the cemetery. Sub 28, he then repeated that even if the vehicle had a visible permit, he would not have allowed it to enter the cemetery. Sub 29, he claimed to have seen a general practitioner but did not have any visible injuries, so he did not obtain a medical report. Sub 30, Constables Marcelo and Mokobi and General Zulu were with him and witnessed the incident. Sub 31, this handwritten statement was subsequently typed by his attorneys and a copy was placed in the docket and accepted as Exhibit C. Sub 32, he conceded that Solidarity had referred him to Herter and Spies, who in turn had referred him to AfriForum. AfriForum thereafter made it clear to the defense that he was not interested in any form of Ubuntu or resolving this matter. Sub 33, his second statement in the docket was dated 28 May 2019, which was 13 months after the incident. Sub 34. This statement gave more detail about the incident but did not correct anything from his previous statement. Sub 35. Even though he had been told over the radio that the Deputy President and heads of state were allowed to enter the cemetery, at no stage did he have a list or know how many people this involved. Sub 36. In paragraph 5.4 of this subsequent statement, which was admitted as Exhibit D, stated, quote, "These vehicles all had permits allocated to them for purposes of identifying them and to grant them access to the designated area," close quote. Sub 37, in paragraph 5 thereof he further stated, quote, "The cars that are referred to in paragraph 2 of my first affidavit referred to the vehicle permits as mentioned above," close quote. Sub 38, in doing so once again he had confused the accreditation of people with the accreditation of vehicles. Sub 39, further having had a year to correct his statement, he further stated at paragraph 5.6, quote, "I recall that all vehicles without the set permits were to be diverted to an alternative designated area for non-permit carrying vehicles," close quote. Sub 40, he conceded that they did not have the whole video of the incident concerning the arrival of all the vehicles and people. Sub 41, he conceded, eventually, that he had watched the video to assist him with the compilation of his subsequent statement. Sub 42, the content of the statement in the docket by the late Zinzi Mandela was then put to him for his comments, but he had no comment in relation thereto, even though it was admitted as Exhibit E, eventually by consent. Sub 43, his further statement dated 18 November 2019 was admitted as Exhibit F. This dealt with vehicle accreditation at paragraph 5 he stated, quote, "I can confirm with certainty that the vehicle in which Mr. Malema arrived at the Memorial Park contained no identifying physical marks confirming that it had the right to enter the designated area," close quote. Sub 44, he then clarified that the identifying physical mark that he was looking for was a vehicle permit. Sub 45, he then yet again further clarified that the vehicle permit was on the left-hand side of the window, clearly visible, that the vehicles that entered from the convoy had permits on the left-hand side in their window. Sub 46, he also repeated that he had not seen such a permit in the vehicle in which both accused had arrived. Sub 47, nevertheless, he also repeated that even if the vehicle had such a permit, he would have stopped it. Sub 48, he also repeated that he had seen all the vehicles of this convoy, except those driving the President and the Deputy President had such a permit on white paper. Sub 49, he was shown the video of the cars arriving during the proceedings on 29 October 2020. He admitted that he could not identify the occupants of the vehicles. Sub 50, he also admitted that it was clear from the video that there was a fourth person in the vehicle carrying the accused. Sub 51, he considered that the large man holding the umbrella with the EFF insignia held him back. Sub 52, eventually having been confronted with a particular part of the video, he considered that there was something prominent on the dashboard of the vehicle. He thought it was a reflection of something there by the window, but had not seen it and had not seen any accreditation. Sub 53, he considered that none of the 12 uniformed people in close proximity had assisted him in what he perceived to be an attack against him. Sub 54, similarly, they took no action when the vehicle entered the cemetery. Sub 55, when confronted with a photograph of the permit on the dashboard of the accused's vehicle, he contended that when his back had been turned, somebody may have put the permit there. Sub 56, he then contended that when he went to the vehicle, the permit had not been visible. Sub 57, eventually, he considered that this was all speculation on his part, that he could not say whether the permit was there or not. Sub 58, in this regard, specific reference is made to Exhibit 4.6, and more particularly the bottom photograph that reflects, quote, 04-14-2018, SAT, being the abbreviation for Saturday, the time being 15:47:05, in which the permit is clearly visible on the left-hand side of the dashboard of the accused vehicle. Sub 59, he had made the decision to not settle the matter by the process of Ubuntu, and had utilized AfriForum to convey that message to the defense. Sub 60, the motorcycles that he contended would be at the back of the convoy. Note detailing where it's found in the transcript.
Sorry to interrupt, Advocate Otis. The court have noticed, and I have seen it as is. It is not necessary to read in the footnotes as well. You are to proceed.
7.3. The relevant testimony of Colonel James Bronkhorst was as follows. Sub 1. On 14 April 2018, he was the acting section head for incident management at the Protection and Security Services at the SAPS. 2. He was notified of an incident that had transpired at the funeral and that Major General Zulu was on the scene and handling the situation. 3. He had been in contact with Mr. Klingbeil to receive a copy of the video footage. 4. He had given a copy of the footage to Colonel Fenter. 5. An internal inquiry had been held, and his conclusion was that Colonel Fenter had acted 100% correctly. 6. Vehicles had to be accredited to be part of the convoy. 7.4. Under cross-examination, considered that 1. He had made 2 statements in relation to this matter, and similarly, neither of them mentioned the term convoy. 2. He was not certain whether the accused vehicle had been secured or accredited for the ceremony at Memorial Park. 3. He had been led in chief in relation to his experience, but not in relation to the specific incident. 4. On 14 April 2018, he was present at VOC and had not been given a list of dignitaries who were entitled to attend the burial ceremony. 5. He had also not been given a list of accredited or authorized vehicles that were entitled to enter the cemetery. 6. In fact, he did not know whether any of those 2 lists ever existed. 7. Additionally, he was not aware of how the procession would take place from the stadium to Memorial Park for the burial. 8. He did not know whether the route from the stadium to the cemetery was open to the public or not. 9. He did not even know who would be speaking at the ceremony. 10. He was unaware of the official program of the funeral service and had not seen it. 11. The people who were described in the program as making tributes would be part of the so-called VIPs of the event. 12. He had no comment in relation to the statement by the daughter of the deceased that accused one was regarded as a family member of the deceased. 13. Accredited vehicles would have an identification sticker or permit registered against the registration number. 14. He was unaware where that remote security process took place in this instance. 15. He could not dispute that the accused vehicle had been through such a process. 16. If the vehicle had such a permit, it was allowed into the stadium and into the cemetery, provided it had been through all the security measures and was part of the convoy. 17. He could not dispute that the accused vehicle had been compliant. 18. Only General Zulu could explain on what basis she had authorized the accused vehicle to enter the cemetery. 19. The vehicles with permits were allowed into the cemetery, those without were not. 20. Usually the hearse is at the back of the convoy, but in this instance he had seen on the video footage that the hearse was not right at the back. 21, he had deposed to two statements that were admitted as exhibits H1 and H2, but had not dealt therein with what vehicles were allowed into the cemetery. Additionally, there was no mention of the term convoy in his statement. 22, the complainant in this matter did not have the authority to stop the accused vehicle if it was in the convoy and had a permit. 23, the incident had taken place at approximately 15:44, but the first time that he had heard from the complainant was around 17:15. 24, he still did not know whether the accused vehicle had undergone the screening exercises. 25, it was an oversight from his side to have completed the internal inquiry without establishing whether the accused vehicle had undergone the screening exercise or not. 26, he had obtained the video footage from Mr. Klingbeil for the internal investigation, not the criminal case. 27, he could see something on the dashboard of the accused vehicle in the photograph thereof, as depicted in Exhibit 4.6. At 28, at no stage did he become aware of a request to VOC for permission to allow the accused vehicle in. 29, subsequent to the event, he was told that General Zulu was there and that she had taken control of the situation. 30, he had not mentioned that he had given Colonel Fenter a copy of the video in his statement. 31, there was doubt because nobody could unequivocally state whether the accused vehicle was authorized to enter the cemetery or not. 32, he had difficulty answering what should have happened if the car was not vetted and had entered because, quote, accreditation was given by General Zulu that the vehicle could go through, close quote. 33, it remained the responsibility of the person that handled the incident. That is why General Zulu should be given the opportunity to come and testify about it. 7.5. Under re-examination he stated, 1, there was not enough communication. Colonel Fenter should have known what was the first and the last car. 2, the only person who can indicate on what basis the accused car was allowed to enter the cemetery would be General Zulu. 7.6, the third relevant state witness was Staff Sergeant Gilbert Molaleki Mapize. He testified that, 1, he had been employed by the military police for 33 years and was doing traffic duties on 14 April 2018 to about 1600 hours, wearing military camouflage and a reflective jacket at Fourways Memorial Cemetery. 2, after the convoy had entered into the cemetery, a Vito came traveling alone and he stopped it. He approached the driver but saw both accused inside the vehicle, so he allowed it to enter, gave them the direction and told them to go straight. 3, this vehicle was traveling alone, had no escort and there were no blue lights. 4, he then heard a noise, saw people pushing each other and proceeded to them. 5, he then came between them. There was an issue about this translation and it was subsequently resolved. 6, accused 2 was furious and asked why they were not being allowed to enter. He then calmed accused 2 down and told him to get into the vehicle. The vehicle then entered with both of the accused in it. 7, he did so because he recognized that there were VIPs in the vehicle. 8, the state then attempted to lead him on his statement with a view to explaining the different versions, but after an objection by the defense counsel was prevented from doing so because it was tantamount to cross-examining their own witness without declaring him hostile. 7.7, under cross-examination he conceded that, 1, by virtue of his 33 years experience he had worked at many state funerals and knew the protocol. 2, this was the first time that he had met Colonel Fenter. 3, since 14 April 2018 he had not seen Colonel Fenter again. 4, there had been no personal interaction between Colonel Fenter and him, yet he claimed to have remembered his name, which was challenged. 5, in his statement he had not mentioned the name of Colonel Fenter. 6, he still maintained that he remembered Colonel Fenter's name even though he had only made a statement more than a year later on 2 December 2019. 7, he could not remember the date of this incident. It was given to him by the investigating officer. 8, in his view, his oral testimony and the written statement were both true. They had both been given under oath. 9, the funeral of Mrs. Winnie Madikizela Mandela on 14 April 2018 was an auspicious occasion and he knew that there were lots of dignitaries, VIPs and members of government that would be there. He had, however, not mentioned this in his statement. 10, he had not been shown the program for the day, Exhibit A, but had watched the proceedings on television. 11, his statement was admitted as Exhibit L. It expressly recorded in paragraph 2 that, quote, on Saturday, 2018-04-14, at about approximately 1600 hours was posted there at the Fourways Memorial Park to control traffic and parking duties. I confirm that the vehicles that were having escort were directed straight to the VIP parking, including the black Vito which was transporting the EFF members. Close quote. 12, he in fact confirmed that this was both correct and true. 13, he had not mentioned stopping the vehicle in his statement. 14, according to him, they had the right to enter because he had seen the VIPs in the vehicle. 15, despite the above detailed express recorded in his written statement under oath, he was of the view that the black Vito vehicle was not part of the convoy. 16, nevertheless, he had confirmed his statement and never indicated that it contained a mistake. It was further put to him that these two versions are irreconcilable. 17, despite having claimed that he had stopped the vehicle, he could not remember how many people had been in the vehicle. 18, he had not looked for a permit because having recognized that the vehicle had VIPs in it, he was of the view that it was entitled to enter the cemetery. 19, in fact, he had been instructed that the VIPs must enter. 20, thus directed them straight to the main gate of the cemetery because all the vehicles were entering through the main gate at the cemetery. 21, he allowed the vehicle to enter because it had VIPs. If that vehicle did not have VIPs, he would not have allowed it to go through. 22, he had no doubt that that vehicle was entitled to enter because it had VIPs and had to enter. 23, accused 2 had questioned why they had been refused entry when they had credentials and were entitled to enter. 24, he had calmed accused 2 down and told him to get into the vehicle so that they could enter the cemetery. 25, he had sent the vehicle directly to the main gate because it was a VIP vehicle. If it was not, then he would have sent it to the left side. 26, he agreed that both of the accused had believed that they were entitled to enter the cemetery for the burial ceremony. 7.8, under cross-examination, he confirmed that he had allowed the vehicle into the cemetery because he had seen 2 VIP gentlemen in it. Paragraph 7.9. In his own defense, accused 1 testified that 1. On the day in question, the security came in the morning to take the vehicle to a road lodge in Grayston, where they would be sweeping the vehicles which were going to the stadium. 2. Very few vehicles were allowed at the stadium. 3. These vehicles were swept by the security and then allowed to proceed under escort of the Metro Police to the stadium. 4. They parked at the basement where the President and former President and heads of state were parking. 5. Even Minister Mbambula was shocked that the accused's car was allowed there because ministers were made to park somewhere and go in buses. 6. He made this point to demonstrate how the vehicle in question had access to enable that he had access. 7. The security was tight, so much so that no one could actually join the convoy if they were not accredited. 8. When they joined the freeway, the off-ramps and the on-ramps were all blocked. Only the cars of the funeral were allowed there on that day. 9. There were motorcyclists. 10. They proceeded. They never had any problem and arrived at the entrance of the cemetery. They were then blocked by Colonel Fenter. 11. It was incorrect for the other witness to say that he had stopped them before. 12. Only in court did he hear what caused the problem. All along he lived under the impression that he was the problem and was not allowed to attend that funeral. His car was never questioned on that day. No one ever had an issue with his car. 13. After he had been told that the car could not go in, he got out because he thought that if he was recognized, the colonel would change his attitude. 14. When he got out, the complainant did the craziest thing. He blocked the car with his body. 15. When you asked him why he was being so dramatic, he started speaking Afrikaans and was agitated. 16. It was a difficult day for him. It was an emotional day for him. Any attempt to stop him from burying his mother would be a humiliation and violation of his dignity as an individual. He was not going to reason with anyone who would want to stop him from burying his mother. He did everything to bury this woman in a dignified manner. 17. He had lived with her, defended her when everybody turned against her, and was not going to allow the situation to be that he would be denied the right to say his last goodbyes. 18. If they had said to him that his car was not allowed, he would have got out and walked into the cemetery, as long as he had an opportunity to bury his mother. But when he was denied access, and despite people knowing how close he was to the deceased, he was still treated in the manner that Fenter had treated him. 19. Passers-by then inquired what the complainant was doing and started to push him. 20. He then went to the driver's seat and told the driver that if he feels scared to drive, he should let him drive the car. It was his car. 21. As he was trying to drive the car, the complainant continued with his shenanigans. 22. He then went back and pushed the complainant, telling him to leave his car. 23. The complainant did not call for backup. He was acting on his own and out of his hatred for them. It later came up that he was an AfriForum member and that AfriForum is an enemy of his organization. 24. They then pushed him and then got into the vehicle and everything proceeded well. 25. If the car had not been allowed to enter, particularly in the presence of the President, former heads of state and heads of state, that car would not have gone in. 26. He inquired what was the point of taking the car through screening if it could just bully itself into the occasion. It would constitute a security risk. If the car did not belong there, they would have had to leave immediately. 27. It was Fenter's attitude, not a police operation. If the car had not been accredited for that occasion, there was no way that they would not have followed up to go and impound it. 28. In such instances, their tow trucks would have impounded the vehicle and called for reinforcement. 29. It was only one man on such a big occasion acting of his own volition without following what were the prerequisites of a person who must man such an occasion. 30. Had he assaulted the colonel in front of all the members of corps that were present, he would have been immediately arrested on the scene. 31. Once it had been declared a state funeral and both the army and the police were in charge, no one would dare undermine such authority. 32. The program, Exhibit A, depicted that he was expected to pay tribute to the deceased at the stadium, so it was unthinkable that he would not be entitled to attend the funeral. 33. He agreed with the statement of the late Ambassador Zinzi Mandela, Exhibit E, and had approached the complainant in the spirit of that statement to find an Ubuntu solution. 34. The decision to occupy the court with this matter rather than resolve it was a political one taken by AfriForum. 35. The convoy had motorcyclists in front and behind. Their car was not the last car because there was a car to block people from joining the convoy. There were motorcyclists behind. 36. The video had been cut before those vehicles entered the cemetery. 37. When watching the video, he pointed out that the unmarked vehicles did not have blue lights, that they were not bumper to bumper. 38. He had pushed Colonel Fenter because he had no justifiable legal reason to stop his car from entering the cemetery. 39. Nobody else attempted to block the vehicle despite the police presence there. Colonel Fenter took it upon himself to stop that vehicle. 40. Nobody had stopped the vehicle out of the cemetery. 41. The complainant did not suffer injuries and nobody did anything to assist him. Nobody ran after the car or obtained the enforcement to go after the car. It merely proceeded inside without any problem. 42. The whole convoy was not visible on the video because the tail vehicle is not visible. 43. On the video you see the hearse entering. It had to be part of the convoy. 44. After the incident, the complainant was seen on a walkie-talkie walking nicely on the video. 45. He had attended the burial and nobody had approached him to tell him that he had no right to be there. 46. He and the other occupants of the car had personal authorizations hanging on their chest. 47. The vehicle was also accredited. 48. The accreditation was visible on the dashboard. 49. Nobody had slipped that accreditation into the dashboard behind the complainant's back. 50. The problem started when the driver identified him as Mr. Malema. 51. On the day he was very emotional and never imagined that anybody would prevent him from burying Winnie Mandela, to whom he had been close for many years, as was known by all South Africans. 52. If anybody had told him that he was not allowed to go in personally, he would not allow that. 53. He repeated that had he been told that he could go in, but not the vehicle, he would have done so. 54. The vehicle had not been stopped. The complainant had attempted to stop him from attending the funeral. 55. The vehicle and its occupants were authorized to enter the memorial center. 56. Culturally, the funeral is important because it provides closure. 57. The convoy is much larger than the complainant had told the court, and he was part of that convoy with motorcycles. 58. These charges emanated from white supremacism, where a white Afrikaner male felt that his fragile ego, had been tampered with. He cannot be pushed by black African children. AfriForum was at the center of this matter. 60. The NPA had coached witnesses and not pursued the mediations. In his mind, it was an embedded NPA. This was despite the state having objected to this line of testimony and the presiding magistrate ruling that it was a fair answer. 61. He had not known Colonel Fenter before this day. He was a tall, well-built Afrikaner male in a police camouflage. He would not have tampered with him unless he felt that an injustice was being done against him. So he had to defend himself against such an injustice. 7.10. Under cross-examination, he stated that 1. He had been traveling in the black Mercedes Vienna vehicle. 2. The delay or gap in time between the BMW X5 and his vehicle was caused by the complainant having stopped his vehicle out of sight of the camera. 3. When the complainant approached the driver, he showed his accreditation. He was then asked whom he was driving. He then responded that he was driving Mr. Malema. 4. He could not see from the photograph what was written on the vehicle's accreditation. 5. Nevertheless, he was adamant that the document visible on the dashboard was the permit. 6. He had not spoken to the complainant but alighted from the vehicle so that he would be able to recognize him. 7. When the complainant started speaking Afrikaans, he realized that there was no cooperation. 8. He had then moved to the driver's side wanting to drive the car himself, and passers-by began pushing the complainant. 9. Despite being pushed, the complainant continued to block the vehicle as if he had been possessed. 10. He did not dispute pushing the complainant. As a result of him continuing to charge at him. 11. When he was joined by accused 2, the protector and other people, the complainant stopped coming forward. 12. He had asked the complainant what he was doing, and the complainant had spoken in Afrikaans, but other people had asked whether the complainant knew who accused 1 was. 13. He had not asked to speak to the complainant's supervisor or senior, but had spoken to the other uniformed policeman because, in his opinion, the complainant was misbehaving. These uniformed policemen pleaded with the accused to please get back into the car and leave him. 14. He was angry and had all the reasons to be very angry. 15. The complainant did not immediately contact the VOC. 16. There was no need to contact the VOC because either the people had the right to enter or they did not. So contacting the VOC is another defense mechanism which must not be accepted. 17. 4 years after the event, he could not remember what he had said in the commotion. 18. The other police officers did not assist the complainant because he was embarrassing them. 19. The complainant was being held back by the other 3 police officers. 20. It did not require the complainant's permission to enter the cemetery because he had the right to do so based upon the prior permission that had been granted to him and in respect of the vehicle. 21. Not only did the other officers not assist the complainant, but they instructed both accused to please proceed to get into the car and enter the cemetery. 22. Accused had asked Officer Mapizi why they had allowed the complainant to stop them from entering. 23. His life was not in danger, but his dignity was. He was being humiliated and denied access to the most crucial moments of the funeral and have closure. 24. He recorded that the presiding magistrate had noted the different versions that had been given to the court by the complainant. 25. In accordance with the process of Ubuntu, he would have apologized if he had made a mistake and expected the complainants to do the same, but the complainants had refused that opportunity because his supremacism would not allow him to meet these monkeys. 26. The lawyers had engaged, but he conceded that the complainant had the right to refuse to follow the process of Ubuntu. 27. Ubuntu made our society unique in that it allowed people to resolve matters amicably without the involvement of the police, but it did not take away the right to open a criminal case. 28. It was Mandela's spirit of Ubuntu where he forgave people who took him to prison for 27 years, so he would have been prepared to forgive a person who blocked his entrance to his mother's funeral. 29. He denied that Staff Sergeant Mapizi had ever stopped his vehicle. In this regard, he recorded that Mapizi's statement was a true reflection of what had happened, that the MP had coached him in a consultation to align himself with a version that he testified to in court, which was contradicted by his own statement. 30. They had not been late for the funeral because the hearse had not yet parked. They only had to be seated once the coffin had been prepared for the burial. 31. When it was put to him that if the complainant had been granted the opportunity to contact the VOC to get permission, none of this would have happened, he responded that one does not need the VOC, you need a permit. Either you have a permit or you do not. 32. Had the complainant told them to leave the car at the entrance but that they would be permitted to go in, they would have proceeded in. This, however, did not happen. 33. The vehicle and they were rightfully there, proceeded through and had not been stopped. The vehicle went to park with the Presidential Protection Unit and VIP protection cars. Nevertheless, nothing happened. 34. They were not obsessed with vehicles. They would have walked in if that had been the case. 35. Not everything had been captured on the CCTV footage. 36. He had hoped that the complainant would recognize him and allow him in, but he had not done so. 37. He had disputed that the complainant looked inside the vehicle because he could not remember accurately how many people had been in the vehicle. 38. Officer Mapizi did not even know how many people were in the vehicle. 39. He had not heard General Zulu saying, leave, leave. 40. It was then put to him that the complainant did not see a visible permit, that he would have stopped the vehicle even if it had a permit because it was not part of the convoy. In response, he said that one is not merely out of the convoy if one arrives after an X5. 41. In re-examination, it was put to him that Colonel Bronkhorst had conceded under cross-examination that whilst he was at the VOC, he had not heard from the complainant until 1715, even though this incident had taken place at 1544. He responded that this confirmed his version that the complainant had not attempted to do anything over the radio, that acted as a person who was possessed and unprofessional. 42. Then watched the video and stated that 3 police ladies in uniform had held back the complainant, not him. 43. He then added the complainant at the radio was not calling for backup, appeared to be in good shape and was laughing. 44. The complainant knew what he had done and the other police officer reminded him that what he had done was wrong. Consequently, he had not sought assistance from any of the other police officers. 45. The complainant did not pursue the vehicle because they had been accredited and through security checks to enter the cemetery. 46. The complainant knew, and if he was honest, he should have confessed that after his investigations he realized that these people had the right to be there. 47. There's no assault with intent. They wanted to bury their mother in a dignified manner and would not allow anything to take that right away from them. He felt justified. 48. If they were wrong, why had the uniformed enforcement officers not taken any action against them? 49. Officer Mapiza and others arrived. They encouraged the accused two to get back into the vehicle and proceed to the cemetery. 7.10.2. Accused 2 also testified in his defense and stated that 1. He had left very early on 14 April 2018 to attend the funeral of Winnie Mandela in his then capacity as the spokesperson of the Economic Freedom Fighters. His duties required him to travel there with the president of the EFF accused 1. 2. He proceeded to accused 1's home where he fetched the car that had been swept, and at all times they were escorted by JMPD vehicles to the stadium and then proceeded in the convoy to the cemetery. 3. There was a small parade before they exited around the casket, and they then proceeded to Memorial Park, properly escorted until they were stopped at the gate. 4. All the off-ramps to the highway had been blocked so that nobody could intercept the convoy. 5. When they arrived at Memorial Park, their vehicle was stopped, but it was not clear to them why they had been stopped. When they inquired from the driver, he said that there had been a concern about the credentials. They were thus being refused entry. 6. Accused 1 requested the driver to open the doors and alighted to engage the complainant. Nobody seemed to cooperate with the complainant who was blocking the car. 7. Accused 2 alighted to attempt to engage the complainant. He was not listening. He just kept saying that they were not allowed entry. 8. They then tried to remove the complainant from obstructing the vehicle. He kept coming back using his body to push back. 9. They attempted to remove him, but he kept coming back to block the vehicle. 10. Both the people and the car were denied entry. 11. They and their vehicle had been authorized to enter. 12. This was after feeling fundamentally violated. Not only had his freedom to movement or the freedom to access Memorial Park been under attack, but also the dignity to mourn somebody that they had a close relationship with. 13. This was a fundamental humiliation. This is a fundamental violation of their dignity, and which strictly speaking had been a right. That is basically how he felt at the time. 14. They could not comply with the complainant's request because he did not have the right to interfere with their dignity, right to mourn, and the right to be there, taking into consideration that they had been cleared to attend the burial. 15. When approached by the investigating officer, was of the view that he had intended to apologize for having subjected them to the humiliation that they had been through for the last 4 years, but had been to in fact charge them. 16. Under cross-examination by the state, he stated further that 1. He had not been part of the program, Exhibit A. 2. He also had not been mentioned in Zinzi Mandela's statement, Exhibit E. Next number, when he alighted from the vehicle, bypassers were not pushing the complainant. He had alighted from a different door. He tried to pull the complainant after he had refused them entry, but he was too strong and pushed him. The complainant kept coming back because he was a strong, large man. His entire objective was to push back against what he saw as a physical mountain of a man who was refusing him entry. The complainant was the violator, provocateur, and was the obstacle preventing him from attending the burial. When viewing the video, he could not say why the police officer's hand was up and pointed towards him, but denied that he was telling him to stop what he was doing. Their rights had been violated to try and bury a loved one, so they constantly had to interact as his humiliation was not easy. The complainant kept trying to get back to the vehicle, and they intended to make sure that it did not stop them from entering because they had a right to do so. He asked the complainant what he was doing and told him that they had the right to be there. He then said that they were not allowed to enter. He then grabbed the complainant. He had not approached any supervisor, and the complainant was not prepared to listen to them. He was angry. They had provoked and humiliated him. They had been seriously mistreated and undermined. when they had all the rights to attend and had been cleared by the institution, and the person who was part of that institution should have been protecting their rights. He denied that the complainant had been humiliated. He had provided the footage to the court and had exercised his power in this instance against mourners. Everybody, including the complainant, knew they had the right to mourn and be there. The complainant was in the wrong. Their funeral and the program had a schedule. They had to get in. They did not anticipate that the complainant would prevent them from participating. He agreed with what accused one had testified and reflected that he was not going to reason with anybody who would prevent him from burying his mother, and described this as being legitimate. To his mind, the context was important because they were attending a funeral that was controlled by the state and had been subjected to multiple checkpoints. The complainant was 100% cerebral and unreasonable. The unreasonable behavior of the complainant seems to them to be a direct violation of their rights, and in that case, the dignity to mourn. General Zulu had been the senior who had let them proceed in. The other officers did not want to humiliate them and appreciate that their car could not have gotten there without it being safe. They acknowledged that they had the right to be there and sympathized with them because otherwise the state's entire protocol is futile if at that instance any car could be let in just because the complainant had been pushed. The state had been in charge and this did not start at the gate. Consequently, he was of the view that it was unreasonable to expect him in those circumstances to ask for the complainant's senior. His life had not been in danger, but his dignity had. His dignity was his life. In any event, the complainant was physical and unreasonable, and his behavior indicated that he did not intend to answer questions from them. 711, under re-examination, stated that the three police officers had restrained the complainant. The lady who had lifted her hand in his vicinity was at least 2 feet away from him. The three police ladies had restrained the complainant. Whilst this was happening, their vehicle had entered the cemetery in the presence of all the other police officers. The hearse that had entered after them was clearly part of the convoy. Both accused had been there in their personal capacities, did not know the complainant, and had not intended to humiliate him. They could not inquire from the complainant whether he had a superior because he was not a conversational person. This was a state event with the state being in charge. Consequently, the state trying to stop them from entering would have deprived them of the opportunity to mourn. The issue of the complainant being humiliated had never been raised by anybody in uniform on that day. Subheading. Response to the state's heads. As in the previous instance, the state's heads of arguments have not been correctly and sequentially numbered. The pages are also not numbered. This makes it difficult to cross-reference the paragraphs when dealing with them. Subheading. Issue is taken with the following submissions in the state's head. 1. Paragraph 8.4, where it is alleged that there was no dispute that Colonel Fento was going to get permission from the VOC to allow the accused vehicle to enter the premises. Your Worship, the cross-reference where it's shown that this is in fact a dispute, Your Worship, is on page 17.
The court have also found it. It
Yes,
is
Your Worship.
in order.
Thank
You
you.
may just continue.
Thank you, Your Worship. Sub 2, in relation to the legal principles applicable to justification, whilst it is accepted that Jonathan Birchall's 5 requirements are correctly set out for the act to be justified on the ground of necessity, and that Snyman contends that the question is not what the threatened person thought was happening, but whether he objectively found himself in an emergency situation on the basis that the regard must be had to the more recent decision of the Constitutional Court in Tutor versus the State. 2022, a decision of the Constitutional Court, ZACC 19, copy of which was attached as Exhibit A and handed to Your Worship.
That is correct.
As Your Worship pleases.
I've also noticed that it is attached. I am not going to require you to read into the
Thank you,
record the
Your
whole
Worship.
case itself. That
I'm
case is
indebted, thank you.
very extensive, and the court have taken it into account for
Thank
its
you.
ruling. You
Yeah.
may proceed.
Additionally, C.R. Snyman deals with grounds of justification as follows. Grounds of justification when his conduct which corresponds to the definitional elements nevertheless not unlawful. There are a number of cases or situations well known in daily practice where an act which corresponds to the definitional elements is nevertheless not regarded as unlawful. Unlawfulness is excluded because of the presence of grounds of justification. Some well-known grounds of justification are private defense, which includes self-defense, necessity, consent, and official capacity. One must always first establish whether an act which accords with the definitional elements is not perhaps justified because the legal convictions of society deem the act committed in those particular circumstances in fact to be lawful. The act is then not unlawful. The grounds of justification must be seen as practical aids in the determination of unlawfulness. They merely represent the situations which are most often encountered in practice which have therefore come to be known as easily recognizable grounds for the exclusion of unlawfulness. They do not cover the whole field of the subject of the discussion, namely the demarcation of lawful and unlawful conduct. The following is an imaginary example of a situation where X's act, which at first sight seems to break the law, is in fact not unlawful, despite the fact that it does fall under one of the recognized grounds of justification. X is the owner of an attractive guest house next to a tarred road. The success of a business depends on the travelling public being able to reach a property via the tarred road. Over the years, the provincial authorities responsible for keeping the road in good order neglect their duties, with the result that the road becomes near to impassable. X complains and asks the authorities to repair the road, but the request falls on deaf ears. At last, she and people in her employ break the existing pieces of tar, remove them, and retar the impassable piece of road. As a result of her actions, she is charged with the crime of malicious injury to property in that she has destroyed parts of the road belonging to the provincial authority. She can then successfully rely on a plea that her conduct was lawful, it accorded with the community's perception of justice or the legal convictions of the community, it caused more benefit to society than any conceivable harm, and was therefore socially adequate. Unlawful does not mean contrary to definitional elements of the crime. The mere fact that the act accords with the definitional elements does not necessarily mean that it is also unlawful. It is therefore incorrect to define unlawfulness merely as an infringement of a criminal law provision or as compliance with the definition of a crime. Such a statement confuses the unlawfulness with the definitional elements. Conduct which is according to general notions of society completely acceptable does not require any justification. That which is justified must necessarily be conduct which is recognizable as a violation of a norm. One can identify the violation of a norm by having regard to the definitional elements of the applicable crime. Subjective considerations are also relevant in establishing unlawfulness. It is sometimes alleged in South African legal literature that the test to determine unlawfulness is objective and that X's intention therefore does not come into the picture when determining unlawfulness or wrongdoing. This view is incorrect. X's or colourless intention forms part of their definitional elements. The latter comprises both objective and subjective factors. The concept of unlawfulness is an evaluation of the act which corresponds to the definitional elements. Since the latter contains both objective and subjective elements, it follows that the former must also be coloured by subjective factors. In order to determine whether an act is unlawful, it is necessary not merely to establish that viewed from the outside, i.e. objectively, the act is in conflict with the legal order, but also to consider X's will or intention. Proving unlawfulness, onus of proof. In terms of the rules relating to the law of evidence, the state's prosecution bears the onus of proving beyond reasonable doubt that X's conduct not only corresponded to the definitional elements, but also that it was unlawful. This means that if in the course of a trial the question arises whether X's conduct is covered by a ground of justification, the onus is on the state to prove that her conduct cannot be justified. In relation to private defense, the Supreme Court of Appeal held in State v. Traynor as follows in paragraph 12. In dealing with the requirement when assessing a claim of private defense that there must be a reasonable connection between an attack and a defensive attack. C.R. Statement in Criminal Law 4th edition states the following at 107. It is not feasible to formulate the nature of the relationship which must exist between the attack and the defense in precise abstract terms. Whether this requirement for private defense has been complied with is in practice more a question of fact than in law, underlined for emphasis. Criminal liability requires fault or a blameworthy state of mind. In Savoy and others versus National Director of Public Prosecutions and another, also a decision of the Supreme Court of Appeal, it was held that the fault element may take the form of either dolus or culpa. In casu, the accused is charged with assault, so it is incumbent on the state to prove that the accused acted with the necessary intention to assault the complainant. In Rex versus Patel, Holmes AJA cautioned against the practice of courts becoming armchair critics and reaffirmed that consideration should be given to decisions that are made in split seconds. The court relied upon Union Government Minister of Railways and Harbours versus Burr at 286, where Ines J.A. said, men faced in moments of crisis with the choice of alternatives are not to be judged as if they had both time and opportunity to weigh the pros and cons. Allowance must be made for the circumstance of their position. In the recent judgment of Tutor versus the state, which I've referred to, the Constitutional Court reiterated the legal position regarding putative private defense and the test to be applied. Unter Alter AJ, with the support of the majority, stated the following at paragraph 46. In Dollar Vera, the appellate division set out the test for putative private defense. An accused who kills another believing his or her life to be in danger when objectively it is not acts unlawfully. However, where such an accused kills another in the mistaken but genuine belief that his life is in danger, the accused lacks the intention to act unlawfully. The accused is accordingly not guilty of murder. The accused may be guilty of culpable homicide. That depends upon whether his belief that his life was in danger was reasonable or not. Putative private defense is thus concerned with culpability and not unlawfulness. Culpability on a charge of murder is judged according to what the accused believed. Culpability on a charge of culpable homicide is determined on the basis of the reasonableness of that belief. Most significant in this regard, the state has conceded that Colonel Fenter, eventually having been confronted with a particular part of the video, considered that there was something prominent on the dashboard of the vehicle. He thought it was a reflection of something by the window, but not seen it and had not seen any accreditation. On the basis of this concession by the complainant and the state, there can be no doubt that the accused defense of justification ought to be upheld. This is particularly so when regard is had to the different justifications given by the complainant for his conduct in preventing the accused and their vehicle from entering the cemetery. These submissions are further fortified by the testimony of Staff Sergeant Mapize, whom the state considered had not even looked for a permit because, having recognized the vehicle had VIPs in it, he was of the view that it was entitled to enter the cemetery. This is further borne out by the further submissions that he directed them straight to the main gate of the cemetery because all the vehicles were entering through the main gate at the cemetery, and under re-examination confirmed that he had allowed the vehicle into the cemetery because he had seen two VIP gentlemen in it. Whilst the state contends that during the testimony of both accused, aspects were raised in their testimony regarding the assault on the day in question, which were not put to the complainant for comment, it is noteworthy that no version was put to the accused and their testimony was not seriously challenged. In fact, it was never put to them that their conduct was not justified. In this regard, the learned authors Zeffert and Paisy state as follows. According to the rule in Brown versus Dunn, the report, a party who calls a witness is entitled to assume that the witness's testimony has been accepted as correct if it had not been challenged. The rule has been consistently followed by courts. To cite a recent instance in State versus Fortain, a 2009 decision, a failure by a prosecutor to cross-examine the accused led to his convictions being set aside. But as has been pointed out by the Constitutional Court in President of the Republic of South Africa and others versus South African Rugby Football Union and others is not inflexible. For instance, it has no application to testimony that is manifestly incredible, nor does it apply where prior notice has been given that the witness's honesty will be impeached. Paragraph 63 of the Constitutional Court's judgment gives, with respect, a most useful survey of how the cross-examiner's duty to challenge testimony must be exercised. It remarks that the precise nature of an imputation against the witness must be made so that it may be met and destroyed, particularly where the imputation depends on inferences drawn from other evidence in the trial. It should be made clear not only that evidence is, but also how it is challenged. This is so because the witness must be given an opportunity to deny the challenge, to call corroborative evidence, or to qualify the evidence given by the witness or others, and to explain the contradictions on which reliance is to be placed. In State v. DiPaolo, it was held to be advisable at least to ask the accused whether he agrees with material allegations made by witnesses for the prosecution. The court must guard against too glib acceptance of an accused's apparent ability to cross-examine, as this can lead too easily to the drawing of adverse inferences against the accused. If the prosecution, however, wishes to contend that the accused's evidence should be rejected, it should cross-examine and give him the opportunity of dealing with the case against him. While there is no absolute rule that a failure by a party to cross-examine a witness precludes him from disputing the truth of the witness's testimony, such a failure, especially by prosecuting criminal proceedings, may, in appropriate circumstances, be decisive in determining the accused's guilt. Of course, a great deal will turn on the circumstance of each case. There may be occasions where a prosecutor may safely decide but not to cross-examine an accused. This perilous course of action should only be taken if at all, after careful consideration when the accused version is manifestly false. The point upon which the witness is to be convicted may be so obvious that it is unnecessary to put it to him in cross-examination, or his story may be so wildly improbable that cross-examination would be a waste of time. In State v. Mancomb, Broom DJP stressed that where the prosecutor wishes to contend that the evidence of the accused should be rejected, cross-examination had to take place. While there is no absolute rule that a failure to cross-examine precluded a party from disputing the truth of the evidence, such a failure, especially where the prosecutor was often decisive. It is advisable for the prosecutor to challenge specific facts in the evidence of the accused which he suggested are false, but the mere fact that one of the exculpatory facts alleged by the accused is not challenged cannot be regarded as implicit admission by the state of the accused evidence on the point. In this matter, it is respectfully submitted that the accused both stuck to their respective versions which in any event corroborated one another and were not challenged on important aspects in cross-examination. In fact, on the estate's above detailed concessions as detailed in respect of its own witnesses' testimony, there can be no doubt that the version of the accused in this matter is far more probable than that of the eyewitnesses called by the state. In this regard, sight must not be lost of the onus that rests on the state to prove the guilt of the accused beyond reasonable doubt. It is trial law that the onus to prove the accused guilt at the end of a criminal trial falls squarely on the state to prove all the elements of the offence beyond reasonable doubt. In this regard, see State versus Heslop. It's quoted, it is a trite principle that in criminal proceedings the prosecution must prove its case beyond reasonable doubt, that a mere preponderance of probabilities is not enough. The onus is on the state to prove the guilt of the accused beyond a reasonable doubt. This means that the accused are entitled to be acquitted if it is reasonably possible that they might be innocent. Reliable and objective evidence serves as a safe measurement to weigh the accounts of witnesses to determine whether the accounts of witnesses meet the requisite threshold. In this case, proof beyond reasonable doubt. In the context of circumstantial evidence that the account given by witness is consistent with all the proof facts to the extent that it excludes every other reasonable inference. The court must be satisfied that the evidence as a whole is beyond reasonable doubt inconsistent with the innocence of the accused in order to convict them. There is no onus on the accused to prove their innocence, and a mere suspicion, even a strong suspicion, is not sufficient to convict them. In effect, therefore, it is submitted that the complainant's justification for his conduct was developed by him into allegations of or accusations against the accused. Nevertheless, as detailed above and in the presiding magistrate's judgment, the justification was tailored on an ongoing basis, so the complainant's version changed. This in turn resulted in the allegations or accusations against the accused similarly being tailored and varied on an ongoing basis. Under the heading contradictions, the state submits that there are contradictions in respect of the facts surrounding the issue of statements taken in the docket. However, there is no material contradictions insofar as the assault that took place on the day in question of the complainant. This is disputed. The only state witness who detailed the assault in statements was Colonel Fenter. His testimony and justification for his conduct is contradictory and cannot be sustained. The state further contends that the assault on the complainant was never disputed. This is not the case and constitutes an oversimplification of the pertinent issues in this matter. The plea explanation and the testimony of the accused made it clear that the issue of mens rea was in dispute. In this regard, both accused were not challenged. They remained steadfast in their testimony that they believed that they were entitled to attend the burial ceremony in the cemetery and that Colonel Fenter was not entitled to prevent them from doing so. There is no evidence to contradict this testimony, and their version in this regard was not challenged. At no stage was it ever put to them that they were not entitled to insist on being in the cemetery in time for the burial ceremony. This in itself should be conclusive of the matter, but at the very least makes it clear that their defense of justification ought to be upheld by this honourable court. The state's reference to previous encounters to justify the conduct of Colonel Fenter is misplaced. Not one of those people had received security clearance and been invited to attend the funeral at the pertinent time. Both of these accused had. Additionally, in each such instance, the complainant stuck to one reason for his conduct. In this instance, as already pointed out by this honourable court, the complainant's justification for his conduct changed throughout his testimony and statements. In this regard, we refer to the decision of Rex versus Blom, where the court held that there are two rules of logic which cannot be ignored when reasoning by inference in a criminal case. Firstly, that the inference sought to be drawn must be consistent with all the proven facts. Secondly, the proven facts should be such that they exclude every reasonable inference from them, save the one sought to be drawn. If these proven facts do not exclude all other reasonable inferences, then there must be a doubt whether the inference sought to be drawn is correct. The court must be satisfied that the evidence as a whole is beyond reasonable doubt inconsistent with the innocence of the accused in order to convict him or her. There is no onus on the accused to prove his innocence, and a mere suspicion, even a strong suspicion, is not sufficient to convict him. Submissions. As testified by the accused, and more particularly accused 2, regard must be had to the context at the time. The court must be careful not to adopt an armchair speculator's approach to the incident in question. Both accused had been accredited and authorized to attend the funeral. It was a matter of international interest. There were time constraints. Colonel Fenter had no justification for not allowing them to do so. Staff Sergeant Mapiza recognized that they were VIPs, were entitled to be at the burial ceremony. All the other officers in the vicinity took no action against them and encouraged them to proceed to the burial ceremony even after the incident. Had the incident been as significant and serious as Colonel Fenter wants this court to believe, the other officers ought to have taken action against the accused. The objective fact that nobody pursued them or regarded the entry of their vehicle into the burial ground as a security threat speaks volumes. These objective factors are the clearest indication that the accused were both entitled to be there. Consequently, their defense of justification ought to be upheld. Whilst it is recognized that the complainant is not obliged to follow the process of Ubuntu and has the right to proceed with criminal charges, such an approach is indicative of his conduct in this matter. Nelson Mandela said the following about Ubuntu, quote, "The power of Ubuntu, the inner core of every person's humanity, could move mountains. Ubuntu is a spiritual ideal, a way of life that is conceptually represented in a whole wide range of sub-Saharan African societies." Conclusion. We have 3 last paragraphs. There are no material contradictions in the testimony of the 2 accused. There are numerous material contradictions in the testimony of the state witnesses. The objective facts and the probabilities favor the version of the accused and militate against the acceptance of the version of the complainant. In contradistinction to the stage when an application for discharge in terms of Section 174 was made, at this stage not only does the state have to prove the guilt of the accused beyond reasonable doubt, but credibility comes to the fore in this assessment. Due regard being had to these trite legal principles, there can be no doubt that the state has failed to prove the guilt of the accused beyond reasonable doubt. Then finally, in paragraph 27, we submit that in the circumstances both accused are entitled to their acquittal. It's signed 19th of August of this year. I beg leave to hand an original copy up to be marked as an exhibit. And I have a copy of that judgment as well, but that's also been handed to your worship. I do not intend to read that out. Thank you very
Yes,
much.
as I've indicated, with regards to the case of S versus Tuta, it's not necessary to read in. It was disclosed to this court, and I believe it was also disclosed to the state. Ms. Hart, you confirm?
Yes, indeed, Your Worship. I confirm I've got no
Thank you.
objection.
So does your heads of arguments will be marked as Exhibit Q. And then attached to the judgment would be also the case of S versus Tuta. I've also noticed it is 15:15. I did not want to interrupt, but if the parties do not wish to go for a break for tea, then we may as well proceed.
We can proceed, Your Worship. Time is of the essence. I have asked the stenographer. She's in order. We can proceed. I just haven't asked. Sergeant is showing we can proceed, Your
I
Worship.
have seen a show of sign that the orderlies are also in a position. I do understand, I have been informed, but I believe load shedding is not going to affect us today in this regard. The court is prepared, if there is load shedding, also to continue with the matter long end as well.
Thank you, Worship.
Please the court, Your Worship.
Thank you. Then I believe then in reply to the heads of arguments by the defense, Ms. Hart, you have also responded to these heads of arguments. May you
Indeed.
then
So, Your
proceed
Worship.
by read that into record.
Before I proceed, I will just give the signed copy, Your Worship, to the court.
Thank you. Just one moment. Thank you. Sir, you may proceed.
Thank you, Your Worship. I will start. States reply to the defense heads of arguments on merits. Introduction. After having received the defense heads of arguments on merits, the state will hereby respond to specific aspects raised by the defense in order not to burden the record unnecessarily. The plea. The defense admits that the obstruction on the day in question was illegal and unjustified in the circumstances. The state submits that the law regarding the functions of a peace office is clear and unambiguous under the National Road Traffic Act 93 of 1996. The purpose and function of the complaint on the day in question was to ensure that only family members of the late Ms. Winnie Madikizela Mandela were allowed to enter the cemetery and no authorized person. In line with this instruction, the complainant was tasked to ensure the compliance thereof. At page 043 of the National Road Traffic Act 93 of 1996, subsection 3J states, fail to comply with instructions or directions of inspector of license, traffic officer, examiner, vehicles, or peace officer 1, no person shall be fail to comply with any instruction or direction given to him or her by a peace officer, or obstructs, hinder, or interfere with any peace officer in the exercise of any power relating to a provision of this Act assigned to him or her in terms of Section 334 of the Criminal Procedure Act 51 of 1977, or thus the state submit that the complainant's action on the day in question can neither be construed as illegal or unjustified under the circumstances. Reply to issue raised by the defense in the state's heads of arguments at paragraph 8.2.1 on page 49 of the defense heads of arguments. In response to page 8.2.1, the state submits that this as was always undisputed evidence, and my learned friend even addressed the confirmation thereof under the following in his heads. Quote, he then said that you will first get permission from the Venue Operations Center, VOC. He then tried to contact the VOC, close brackets. Reference are made to transcripts 2810 of 2020, page 14. At page 8.2 on page 55 of the defense heads of arguments, the state submits that for the court to decide on the issue of justification, the following should be taken into consideration during the evaluation of evidence. 1. The complainant testified that he required the necessary permission to allow them to enter the premises, which at the time he was in the process of doing, and has highlighted in the state's initial heads of arguments. Reference also is made to paragraph 7.1.11 of the defense heads of argument. 2. This should be considered in line with the submission made by the defense in its heads of argument under paragraph 7.1.10 and 7.1.14. At paragraph 11 on page 57 of the defense heads of argument, the state submits that throughout the testimony of both the accused, they failed to meet the threshold for the defense of justification as clearly set under the state's heads of argument. At paragraph 12 of page 57 of the defense heads of argument, it should be the state, your worship, submits that the evidence before this court is not only restricted to viva voce evidence, but also include the real evidence in the form of the video footage which corroborates the evidence of the witnesses insofar as the charge levied against both accused. In S versus Chabalala 2003, brackets 1 SACR 134 SCA, here AJA at 140 A to B. Quote, the correct approach is to weigh up all the elements which points towards the guilt of the accused against all those which are indicative of his innocence, taking proper account of inherent strengths and weaknesses, probabilities and improbabilities on both sides, and having done so, to decide whether the balance weighs so heavily in favor of the state as to exclude any reasonable doubt to the accuser's guilt. The result may prove that one set of evidence or one defect in the case of either party, brackets such, open brackets, such as a failure to call a material witness concerning an identity parade, close bracket, was decisive. But that can only be on an ex post facto determination, and a trial court, bracket, and counsel should avoid the temptation to latch on to one, bracket, apparently obvious aspect without assessing it in the context of the full picture in evidence. Paragraph 13 of page 58 of the defense heads of argument. The state takes cognizance of the presiding officer's judgment at the time of the Section 17 publication. However, when looking at the evidence as a whole, at this point in time, the state refers to S versus Slongwa 2010 to SACR 416 SCA, wherein the court referred to S versus Henderson. The Henderson court is emphatic that human memory is not foolproof. Research has revealed that human memory is not like a video recording that a witness is only to replay to remember what happened. Memory is far more complex. The process of remembering consists of 3 stages: acquisition, the perception of the original event; retention, the period of time that passes between the event and the eventual recollection of a piece of information; and retrieval, the stage during which a person recalls stored information. At each of these stages, memory can be affected by a variety of factors. Some aspects of the complete jury instruction on eyewitness evidence issued by the New Jersey Supreme Court are that whether the witness was under a high level of stress, even under the best viewing conditions, high levels of stress can reduce an eyewitness' ability to recall and make an accurate identification. How much time the witness had to observe the event. Time estimates given by a witness may not always be accurate because witnesses tend to think events lasted longer than they actually did. Memories fade with time. The more time that passes, the greater the possibility that a witness's memory by perpetrator will weaken. At paragraph 14 on page 58 of the defense heads of argument, the state submits that notwithstanding the above, there is real evidence which corroborates the aspects surrounding the assault on the complainant on the day in question. Further, Sergeant Mapisa also observed the assault on his arrival on the scene. And reference is once again made to S versus Maleficio and others. Oliver J. A set out the approach to be followed when a court is faced with evidence of this nature. The following approach to contradictions between two witnesses and contradictions between the versions of the same witnesses, brackets such as inter alia between user habeas voce evidence and a previous statement, close bracket, is identical. Firstly, it must be carefully determined what the witness actually meant to say on each occasion in order to determine whether there is an actual contradiction and what is the precise nature thereof. In this regard, the adjudicator of the fact must keep in mind that a previous statement is not taken down by means of cross-examination, that there may be language and cultural differences between the witness and the person taking down the statement which can stand in the way of what precisely was meant, and that the person giving the statement is seldom, if ever, asked by the police of to explain their statement in detail. Secondly, it must be kept in mind that not every error by the witness and not every contradiction or deviation affects the credibility of a witness. Non-material deviations are not necessarily relevant. Thirdly, the contradictory versions must be considered and evaluated in a holistic basis. The circumstances under which the versions were made, the proven reasons for the contradictions, the actual effect of the contradictions with regard to reliability and credibility of the witness, the question whether the witness was given a sufficient opportunity to explain the contradictions, and the quality of the explanation, and the connection between the contradiction and the rest of the witness evidence, amongst other factors to be taken into consideration and weighed up. Lastly, there is a final task of the trial judge, namely to weigh up the previous statement against the viva voce evidence, to consider all the evidence and to decide whether it is reliable or not, and to decide whether the truth has been told despite any shortcomings. At paragraph 15, 16, and on page 58 and 59 of the defense heads of argument, the state submits that it was never in dispute that the two accused wanted to attend the funeral. However, the state always challenged the conduct of both accused at the time, as indicated earlier. The complainant only wanted authorization for them to enter, notwithstanding the fact that when they were cross-examined as to why they did not give the complainant an opportunity to do so, and also requested someone senior to address the issue. The issue of mens rea was covered with the response highlighted in the initial state's heads of argument when dealing with the response by the accused which did not meet the threshold for the purpose of justification, dated at Randburg on the 1st of September 2020, signed, Your Worship, by myself. Please support, Your Worship.
Thank you. The reply to the heads of arguments to the defense by the state is being marked as Exhibit R. To be fair, Advocate Otis, I have not received any reply to the state's reply in this regard. Do I believe or do I accept that there's no further reply by the defense and that the defense is standing by the heads of arguments as indicated to?
There was no provision, because as I understood it, that they had a right of reply because they went first. So there was
Yes,
no,
so I'm
I
just...
never believed that you had a right to
So-
further replies. It would carry on endlessly. So, but I have no further submissions.
No
I
further
stand by my
submissions. I just thank you then.
Thank you.
As indicated, the court will proceed, and if load shedding does occur, we will just continue. The court is prepared then to proceed in terms of the matter, even if it is to do the matter long. And this matter is long outstanding, and we need to come to a conclusion with this case itself. At this stage, I'm not going to require Mr. Malema nor Mr. Ndlozi to stand. They may remain seated. I will only require them to stand at a later stage in the matter itself. But for now, they may remain seated. The court have also prepared a judgment, and I've omitted in terms of the judgment to acknowledge that the accused is being represented by Mr. Ian Livett as the instructing attorney, and that they are also been, that Mr. Otis is also then been briefed as the advocate who was conducting the matter. So the court do recognize Mr. Ian Livett as the instructing attorney in the matter itself. Therefore, the court will proceed with judgment. In terms of the judgment itself, in the Magistrate Court for the District of Johannesburg North, held at Randburg, case number 3/4/067/2019, in the matter between the state versus Julius Malema and Mbuyiseni Ndlozi. judgment. 1. Introduction. In the matter, the state prosecuted Mr. Julius Malema and Mbuyiseni Ndlozi on a charge of assault. Accused 1, Mr. Julius Malema, is a 38-year-old male, and accused 2, Mr. Ndlozi, is a 34-year-old male, as per the charge sheet dated 2019. The accused was then legally represented by advocate holders as well as the instructing attorney, Ian Levitt. For all record purpose, when the court referred to VOC or VOC, it should be interpreted to be venue operation service. 2. The plea. Both accused pleaded not guilty to the said charge. Advocate Holders confirmed the plea of both accused was in accordance with his instruction. Mr. Holders stated that the accused elect to make the following plea explanation. The ground of justification. Both accused believe that they were entitled to enter the cemetery for a burial ceremony, that the obstruction of them was illegal and unjustified. In the circumstances, they lack mens rea because they believe, at the very least, that they were entitled to enter the cemetery for the burial. Further, that there is a political agenda here at play. This is an assault case. They both reached out to the complainant by way of Ubuntu. That was rejected by AgriForum. So this turns out to be that there is a political agenda between AgriForum and the EFF, which is being played out here in this court. Both accused has confirmed the statement by advocate holders. No formal admissions at that stage was recorded. The trial itself, at the closure of the state's case, the accused made an application for their discharge in terms of Section 174 of Act 51 of 1977. The application was also opposed. The application was further dismissed for reasons given then and will not be repeated in this judgment. 4. Evidential material considered. The state adduced the evidence of 6 witnesses, namely Colonel Johannes Jacobus Venter, Dion Klingbeil, Colonel James Bronkers, Colonel Charles Sianego, Warrant Officer Jacobus Nicholas Vosloo Smith, and Staff Sergeant Gilbert Mapisa, who testified under oath. Mr. Jacobus Venter testified that he is employed with the South African Police Service and is stationed at Presidential Protective Service, Head Office Pretoria. He is employed as a Lieutenant Colonel with 36 years of experience and 6 years at the Prudential Protection Services. His duty is as follows: a planning officer responsible for the protection of the President, Deputy President, the heads of states, and the former heads of states of the Republic. The incident happened on the 14th day of April 2018. There is a typing error in terms of the judgment to indicate it is 19, but it is 2018. Court repeat. The incident happened on the 14th day of April 2018 at approximately 15:40. He had been posted at Four Ways Memorial Park Cemetery at the outside perimeters, which involved the main gate of the cemetery, with 2 other ladies. His evidence referred to the 4 separate incidents which occurred before the arrival of the hearse. A lady from England, a man from Limpopo in a SUV, and followed by another vehicle, and the 2 ladies who arrived earlier and wanted access. All request entry into the cemetery. Ms. Erasmus from the administrative section of the cemetery explained to the first 3 that they cannot enter or because of the state funeral for the late Ms. Winnie Mandela. And the last 2 ladies was informed by Mr. Mandla Mandela, that they needed to wait. They all understood and left. The 2 ladies with accreditation around the necks also understood the refusal of entry because no one was allowed to enter before the family. Later, at 15:30 and to 15:40, the convoy arrived. First, the hearse, which went to park on the right-hand side of the road. It was followed by the family, president, deputy president, heads of states, and former heads of states, and ministers. After vehicles has entered, a black Mercedes-Benz approached the gate. He did not see any visible permit. The permit gives you permission to enter, and it will be on the left side of the vehicle's window. He stopped the vehicle and went to the driver, who informed him that the leader of the EFF is in the vehicle. He informed them that the vehicle cannot go in, but they are more than welcome to walk into with other guests. Mr. Malema has informed him that he will not walk in, but drive in. The court will just repeat. Mr. Malema has informed him that he will drive in, and he said that he must first confirm with VOC. He tried to contact VOC, standing in front of the vehicle's right-hand side. He was then bumped or pushed by someone who he could not see. He then saw Mr. Malema jump out of the vehicle, saying, "No white man will stop me." He was then pushed a second time, but also could not see who it was. He then moved to the front of the vehicle, where he was pushed by both accused. The second push was also so hard that he lost his balance and fell against the guardhouse. The first time they pushed him, he went back to the middle of the vehicle, and after they pushed him again, he never retaliated. At some point, the vehicle drove in. Mr. Malema and Mr. Ndlozi got back into the vehicle, and they drove into the cemetery. Neither himself nor General Zulu has given the vehicle permission to enter. The reason for stopping the vehicle of the accused, the whole convoy was already inside the cemetery. There was no escort with the vehicle, and he did not see a visible permit. The convoy was led by a motorcade of military in front, and at the back there was also traffic vehicles. He had been instructed by Lieutenant Colonel Mutaung that only the immediate family and the president could enter the cemetery, and the rest of the people will remain at the stadium, where big screens had been erected to televise the funeral proceedings. The accused had personal permits around their necks, but he had not seen a visible vehicle permit, and even if the vehicle had such a permit, he would not have. Court will just repeat the sentence. The accused had personal permits around their necks, but he had not seen a visible vehicle permit, and even if the vehicle had such a permit, he would have still stopped the vehicle because it was not part of the convoy. The cars which had permits to enter were in the convoy of the Mandela family, the President of the Republic of South Africa, followed by the Deputy President and the heads of state. He was shown a map which he identified the parking arrangement and where VOC was situated. He further confirmed the assault on the video footage which is before court. The following was elicited from him during cross-examination: accreditation of the vehicle, how many people was in the vehicle, whether General Zulu gave permission to enter, how many vehicles made up the convoy, what will be the first and the last vehicle to enter, had no list, or whether he had a list of people as well as vehicle which would attend the funeral. And then the version of the accused was also put to him, the right that they have, the right that they are allowed to be there. 5, the next witness was Mr. Dion Klingbill. He is employed at Memorial Cemetery Park, Fourways, as an operational manager since 2007 and was at work on the 14th of April 2018. He confirmed that there is cameras at the cemetery. The cameras was installed in 2016 and it was in a working condition. He further explained where the cameras were situated and where the control room was. He was also approached by Colonel Bronkers for the video footage which he has downloaded on a USB stick. He made a copy for himself, and after the docket went missing, he was requested by Colonel Nama to make another copy. This was done from his own copy because The safe copy on the hard drive no longer exists. 6. The state then called Mr. James Bronkers. He is employed at the South African Police Service for 34 years and is stationed at the Protection and Security Service. He falls under the Incident Management section, which he is the head of, which directly report to the head of the VIP protection. There are 2 sections, Incident Management and Contingency Management. On the 14th of April 2018, he was the acting section head for the Incident Management at the Protection and Security Service at the SAPS. His duties was to give support to the Operation Section, monitor all radio communication around the protection services, handle all the incidents and handle all the incidents that take place, activate the contingency plan, and will be the link between the protection services and all other role players. He was notified of the incident at the gate by Colonel General Slabane, Divisional Commissioner of Protectional Services, and the General Zulu was on the scene and handling the situation. He made contact with Mr. Klingbeil to receive a copy of the video and also gave a copy to Colonel Venter. An internal inquiry was conducted and it was found that Colonel Venter acted 100% correctly. He further gave evidence in general concerning the protocols which was followed. The following was elicited from him during cross-examination. He was not sure whether the accused vehicle was secured or accredited for the ceremony at Memorial Park. He was present at VOC and has not received any list of dignitaries who are entitled to attend the burial ceremony. He could not dispute that the accused vehicle was compliant. Only General Zulu could explain on what basis she had authorized the accused vehicle to enter the cemetery. He further confirms that the complainant did not have the authority to stop the accused vehicle if they was in the convoy and had all necessary permits. It was also an oversight on his part to close the internal investigation without verifying that the accused vehicle had no permit. 7. The next state witness which was called was Mr. Charles Sianego. He was the investigating officer in this case. Prior his retirement, he had 42 years of experience in the South African Police Service. He has obtained the video footage from Mr. Klingbeil. Upon receipt of the video footage, he placed it in a forensic bag and booked it into the SAP-13 record. He has further taken the footage to cybercrimes as well. Under cross-examination, it became apparent that he has a very poor recollection of what have transpired in this case because it have happened so long. 8. The next state witness which was called was Jacobus Nicholas Vosloo. He was a warrant officer at Cybercrimes and Deep Web Investigation Detective Services, head office in Pretoria. He has also compiled a photo album which is before court as Exhibit 4. He basically testified concerning the authenticity of the video footage. He further explained the procedure followed in doing so and the protocol concerning the sealing of exhibits in exhibit bags. 9. The last state witness was Mr. Gilbert Mapisa. He is employed by the Johannesburg Military Police as a staff sergeant with 33 years of experience. He was stationed outside Memorial Park Cemetery. He stopped the accused vehicle after the convoy has entered, which was a vehicle came, which was traveling alone. After noticing the accused, he directed them to the gate because he recognized that there was VIPs in the vehicle. Afterwards, he just heard noises, saw people pushing each other and approached them. He came between them, and accused 2 was furious and asked why they are not being allowed to enter. He then calmed accused 2 down and told him to get back into the vehicle. The vehicle entered with both accused in it. Under cross-examination, his statement Exhibit L was put to him concerning the discrepancies or contradictions. I quote Exhibit L, paragraph 2. On Saturday, 14th April 2018, at about approximately 1600 hours, I was posted there at the four-way Memorial Park to control traffic and parking duties. I confirm that the vehicle that were having escort were directed straight to VIP parking, including the black Vito, which transported the EFF members. This statement is dated 2nd December 2019 and so signed and commissioned. This is about 18 months after the incident and about 3 years afterwards that he had given oral evidence in court. The state further wanted to call General Zulu under paragraph 10, but an application for postponement was refused, and the state have then subsequently closed their case. 11, the following documents was received by consent of the parties, and the court ruled that it is received by consent and admissible as evidence before the court. Exhibit 1 or Exhibit A is the program for the funeral services for Ms. Winnie, the late Winnie Mandela. Exhibit B, witness statement of the complainant. Exhibit C is a typed version of the complainant's statement. Exhibit D is also a statement made by the complainant. Exhibit E is then the statement by Ms. Zinzi Mandela. Exhibit F is also a statement by Johannes Jacobus Venter. Exhibit G1 to G3 is statements done by Dion Klingbeil. Exhibit H1 to H2 is statements done by James Bronkhorst. Exhibit J1 to J6 or Exhibit J1 to J4 is statements done by Charles Sianego, and then Exhibit J5 and J6 is the SAP 13 criminal record, or SAP 13 record rather. Exhibit K1 and K2 is then statements done by Mr. Vosloo Smith in this regard, as well as Exhibit K3 and K4. Exhibit L is then the statement done by Mr. Mampisa. The court has also received the following real evidence, which was received by consent, and the court ruled that it was admissible as evidence before the court. Exhibit 1, 2, 3, 4. Exhibit 1 is photographs depicting the parking spaces. Exhibit 2, photograph depicting the parking spaces as well. Exhibit 3 then refers to the video, and Exhibit 4 is the photographs compiled by Mr. Smith. 13, that include the evidence, this conclude the evidence for the state. 14, on behalf of the defense, only the accused testified under oath. On behalf of the defense, the two accused before court have testified under oath in this case. The defense did not call any further witness other than the two accused. 15, the defense called its first witness, Mr. Malema, who testified as follows. He started his evidence prior the day of the incident when they went to bring their condolences to the Mandela family. He was then taken outside by the two daughters of the late Ms. Winnie Mandela. They informed him that the ANC and the state did not want him to speak and said it is a state's funeral. However, they made it clear that he will be speaking, otherwise they will decline the state funeral and bury her themselves. Testifying in this case made him relive the painful day of the burial of his mother. In the morning of the day of the incident, his security came to take the vehicle to a road lodge in Grayston, where it was swept and taken to the stadium. It was only a few vehicles which was allowed to the stadium. Not even ministers' vehicles was allowed. Only the minister who were part of the preparation, the preparatory committee was allowed. There was shuttle services provided on the day where ministers will park and get into the buses. His vehicle, a Viano Mercedes-Benz, was accredited and was allowed to proceed with an escort of Metro Police to the stadium. At the stadium, they parked with the president, former presidents, and heads of state. After the event at the stadium, they left for the cemetery and security was tight. You could not join the convoy if you were not accredited, and all the on and off ramps to the highway to the cemetery was closed. They never had a problem until they were stopped by Colonel Venter. He only established in this court that his vehicle was the problem and that he was always living under the impression that he was the problem. That his vehicle, that he was the problem who was not allowed to enter. When he was informed that the vehicle could not enter, he got out hoping that Colonel Venter would recognize him and will change his attitude. He then saw the craziest thing, which he never saw in the police personnel. He stood in front of the vehicle with stretched out arms blocking the vehicle. When inquired what he was doing, he started to speak Afrikaans when they did not understand. He did not understand him. This made him agitated because this was a very difficult and emotional day for him. Any attempt to stop him from burying his mother will be a humiliation and a violation of his dignity as an individual. He will not reason with anyone who wants to stop him. He lived with her, defended her when everyone turned against her, and will not be prevented from saying his last goodbyes. If I was informed to leave my vehicle, he would have then complied and walked in. Passerbys has started to push him, saying, "Do you not know who this man is?" When he continued with his shenanigans, he went to him and pushed him, saying that he should leave the vehicle. He pushed him and then proceeded in with the vehicle. After everything proceeded normally. If the vehicle is not accredited, it would pose a security risk. His vehicle was compliant and was not towed away, nor was reinforcements called to come and deal with the situation. It is also unthinkable that he is not allowed at the burial site. A lot of the late Miss Winnie Mandela's grandchildren who were not on the program was also there. He confirms Exhibit E because they are not proud of what have happened and try to resolve the matter by way of Ubuntu. In respect of the video, he indicated that it did not depict all the events of the incident. He confirmed that he has pushed Colonel Venter for the following reasons: to get away from the front of the vehicle so that he could enter because he had no justifiable reason to stop their vehicle. While pushing him, the vehicle entered. They were no longer stopped. He confirmed that their accreditation depicted as per Exhibit 4. Culturally, being stopped had the following effect on him: denied closure. If you do not get closure and things don't go right, you keep on blaming that occasion where you not allowed to say goodbye to a loved one. And it is a ritual, but it is also a healing process. In closing, he indicated that the police get pushed on. In closure, he indicated that the police get pushed all the time, and if police were to open common assault cases against people who push them when executing their duties, you can just imagine that this court will be overcrowded with unnecessary cases. 16, the following was elicited from him during cross-examination: the accreditation of the vehicle, the delay after the BMW X5, the accreditation on the dashboard, whether he requested or spoke to Colonel Venter's supervisor, his state of mind when he pushed the complainant, the other 3 police officers, whether his life was in danger or not, and whether they were stopped. 17, the defense then called Mr. Ndlozi. He indicated to the court that on the 14th of April 2018, he was the spokesperson for the EFF, and his duties was to travel with the president of the EFF, Mr. Malema. He woke up early in the morning to attend the funeral of the late Miss Winnie Mandela. After the vehicle was swept, they went to the stadium with JMPD escort. After the proceedings at the stadium, they joined the convoy to go to Memorial Park Cemetery. All the on and off ramps to the cemetery was blocked off. At the gate of the cemetery, they were stopped, but it was not clear why they are being stopped. When they asked the driver why they are being stopped, he said that there had been a concern about their credentials. They would thus refuse entry. Mr. Malema went out to engage Mr. Venter to no avail. He then got out on the other side of the vehicle to engage Mr. Venter, but Mr. Venter failed to listen and just said that you are not allowed to enter. The idea was then to push him as far out as possible so that they can enter, but he kept on coming back using his body to push back. Both the people and the vehicle was denied entry even though they had lanyard accreditation around their necks and the vehicle had a permit to enter. The effect of not being allowed to enter was a fundamental violation of their right, denial of their freedom of movement and the dignity to mourn. He was not prepared to comply with Colonel Venter's instruction not to enter because not even a police officer has the right to interfere with our dignity, right to mourn, and the right to enter the cemetery. 18, the following was eliciting from him during cross-examination, that he was not being part of the program as depicted on Exhibit A. He is also not mentioned in Exhibit E. Questions about the video footage, how he pulled and pushed the complainant, why one of the police officers' hand was raised at him, but he denied that it was to stop him, whether he had approached the supervisor of the complainant, state of mind, whether he was angry, whether they had a right to enter. 19, that concluded the evidence for the defense and the case was closed. 20, both the public prosecutor, Ms. Hart, and the legal representative of the accused, Mr. Houders, submitted the heads of argument and the state's reply to. The court do thank both parties for their timeously submission of the heads of arguments for the court then to be in a position to deliver judgment today. 21, the state submitted overall that it had proved its case beyond a reasonable doubt that the accused should be convicted based on the following reasons. That the accused acted in common purpose when they assaulted Colonel Johannes Jacobus Venter. That the accused did not have any justifiable ground to assault Colonel Venter. That the defense of necessity and putative necessity is not applicable since the life of the accused was not in danger. There is no evidence on record to show that there was any harm or that harm was imminent on the accused. That a person cannot escape criminal liability if he is the cause of the default. That it was not necessary for the accused to avert the threat in the manner they have, and that they should do, and that they have done more harm than what is necessary. Even if there is contradiction, discrepancies, they are not material. Not every discrepancy in a statement affect the witness credibility. 22, the defense submitted that the accused be acquitted on the count of assault because the state failed to make out a case beyond a reasonable doubt based on the following. There are no contradictions in the version of both accused. There are numerous contradictions, discrepancies in the evidence of the state witness. The objective facts and the probabilities favor the version of the accused and militate the acceptance of the version of the complainant. The contradictions or discrepancies affect the credibility of the state witnesses and the version of the state witnesses' evidence, and that the court should consider that discrepancies is material. 23. The approach to the evaluation of the evidence was stated in the case of S versus Reiner at 41 paragraph 9 as follows. A conspectus of all the evidence is required. Evidence that is reliable should be weighed alongside such evidence as may be found to be false. Independently verifiable evidence, if any, should be weighed to see if it supports any of the evidence tendered. In consideration whether the evidence is reliable, the quality of that evidence must be necessary, be evaluated, as must be corroborative evidence, if any. Evidence, of course, must be evaluated against the onus of a particular issue or in respect of the case in its entirety. 24. The court must consider the totality of the evidence in order to ascertain whether all the particular prerequisites for the crime are present and whether the guilt of the accused has been proven beyond a reasonable doubt. In order to establish the answer to the question, the court must have regard to the credibility of the witness, the probabilities, and the authority concerning the matters of this nature. In the case of S versus Jackson, the citation is as per the footnote. The court is not going to read into record the footnotes itself. It will be available to both parties to go through the footnotes itself. In 25, the case of S versus Jackson, the court held that the burden is on the state to prove the guilt of the accused beyond a reasonable doubt, no more and no less. There is no burden of proof on the accused to establish his innocence. 26, in South Africa, many attempts has been made to define the standard of proof in many cases. The phrase reasonable doubt in the phrase proof beyond a reasonable doubt cannot be precisely defined, but it can well be said that it is a doubt which exists because of probabilities or possibilities which can be regarded as reasonable on the grounds of general accepted human knowledge and experience. Proof beyond a reasonable doubt cannot be put on the same level as proof beyond the slightest doubt, because the onus of adducing proof as high as that would in practice lead to the defeating the ends of justice. 27. This then implies, as per the case of R versus Malambo, which was also approved by A.J. Oliver in the dictum of A.J. Malan. In my opinion, the court quote, in my opinion, there is no obligation on the Crown to close every avenue of escape which may be said to be open to an accused. It is sufficient for the Crown to produce evidence by means of which such a high degree of probability is raised than the ordinary reasonable man. After mature consideration comes to the conclusion that there exists no reasonable doubt that an accused has committed the crime charged with. Thus, proof beyond a reasonable doubt does not mean proof beyond a shadow of a doubt. 28, in the case of S versus Manini, A.J. Cameron gave this description of the criminal standard. It is sometimes said that proof beyond a reasonable doubt requires the decision makers to have moral certainty of the guilt of the accused. Though the notion of moral certainty has been criticized as imparting potential confusion in jury trials. It may be helpful in proving a contrast with mathematical or logic or complete certainty. It comes down to this. Even if there is some measure of doubt, the decision maker must be prepared not only to take moral responsibility on the evidence and the inferences for convicting the accused, but to vouch that the integrity of the system that has produced the conviction in our case, the rule of evidence interpreted within the precepts of the Bill of Rights remain intact. Differently put, subjective moral satisfaction of guilt is not enough. It must be a subjective certification attained through proper application of the rule of the system. 29. Further, if there is a reasonable possibility that the version of the accused may be substantially true, then he must be acquitted insofar as his version constitutes a crime or offense on which he may be convicted. 30. I have therefore considered the definitional elements of the offense in relation to the facts in dispute to establish whether the state has proved the elements that are in dispute. According to assault by Milton at 406 defines assault as follows. Assault consists in unlawful and intentionally applying of force to the person of another or inspire a belief that force is immediately to be applied to him. Assault is defined by Snyman on page 403. Assault consists in unlawful and intentionally applying force directly or indirectly to a person of another or inspiring a belief in another person that force is immediately to be applied to him or her. 31. The elements of the effect is the act. The element manifests itself in one or two ways, namely through the application of violence and through threats of violence. Unlawfulness. The legal convictions of the community requires that the physical integrity of a person should be protected. This, however, does not mean that every impairment of the said physical integrity will constitute unlawfulness. The impairment of the physical integrity of a person will be unlawful when, according to the objective reasonable criteria, it is unreasonable. Also, intention. The perpetrator must have the intention to apply violence to another person, see Rebo, in this regard, or the threat or threaten him in such a way that a belief or fear is inspired in the mind of the latter with the above mentioned qualification. 32. The facts not in dispute. The date, time and place of the incident, that the accused was stopped by Colonel Venter, that mediation failed. There are no dispute with regards to all the exhibits before the court, and the court has accepted all the exhibits as evidence and ruled that it is also admissible as evidence before the court. The facts in dispute, the court is only going to basically deal with the two main issues. Those are the real facts which is then in dispute. The justification of the assault and the intention of the accused, which is in dispute between the parties. 34. The court considered the evidence of the state witnesses. I will, however, only deal with the evidence of Colonel Johannes Jacobus Venter and Staff Sergeant Gilbert Mapisa for purpose of this judgment, because all other witnesses such as Dion Klingbeil, Colonel Charles Sianego, Warrant Officer Johannes Nicholas Vosloo Smith, evidence is basically not in dispute. Their evidence point to the obtaining, investigation which was done, in the gathering and the verification of the authentication of the video and the lost docket reconstruction. Although the evidence is not the most satisfactory and may be subjected to criticism as well, I found that all of them has made errors in regards to their statements they made, and others also had loss of memory when confronted with specific details of the case itself. Irrespective of these inadequacies, I found that most of the evidence don't take the state's case any further, and most is not in dispute, and the errors become immaterial in this regard. Therefore, after carefully considering the evidence, there are no inherent improbabilities in the evidence, nor could I find any indication that the evidence was fabricated. The defense heads of arguments under 35, paragraph 35 of the court's judgment. The defense heads of arguments refer the court once again to the evidence of 3 witnesses, which was important for the defense to allude to the court, which was the evidence of Johannes Jacobus Venter, Colonel James Bronkers, and Sergeant Gilbert Mapisa, which would be relevant. I have indicated that I will only refer to 2 of the state witnesses. Due to the following reason: Colonel James Bronkers did not witness the assault, nor does he have any direct evidence of the assault. He was only informed of the incident at a later stage. He could only assist the state's case in testifying of how the video footage came to be and what he perceived the procedure to follow at the state funeral out to be. He also did not successfully convince the court that the accused vehicle was not allowed to enter the cemetery. He was not even aware of how the procession would take place from the stadium to Memorial Park Cemetery. He did not have a list of the dignitaries in accredited or authorized vehicle and people that were allowed to enter the cemetery, nor was he aware of its existence. He failed to dispute that the accused vehicle had been compliant. He has also come to a conclusion, after he had obtained all the information of his internal investigation, that the complainant has acted correctly, but concede in the same breath that he failed to verify whether the accused vehicle went through a security checkpoint or screening. He has therefore confirmed that it was an oversight on his part to have completed the internal inquiry without establishing whether the accused vehicle had undergone such screening or not. His evidence is given in a general perspective and not always have a direct reflection of the merits of this case. He was also sure that if the vehicle had a permit, it was allowed into the stadium and the cemetery, which also contradicts then the version of Colonel Venter's belief that if the vehicle had a permit, it could have only be for the stadium and not for the cemetery. Therefore, after properly considering the consideration of his evidence in light of the totality of the evidence, he did not impress the court that the version that Colonel Venter acted correctly should be believed. It appears to the court that the internal investigation was completed with a lot of shortcomings. However, due to my ruling in terms of the Section 174 application, I have already indicated the views of this court with regards to the accused's vehicle permit to enter the cemetery in this regard. I will, at this stage, not take this point any further. Due to the Section 174 application, I've already indicated that the court have believed that the accuser's vehicle had a right to enter in this regard. In the evaluation of the evidence of Colonel Venter, Johannes Jacobus Venter, the court remarks as follows under paragraph 36. He is the person who has stopped the vehicle of the accused and denied them entry. After he refused entry, he was assaulted by way of pushed by both of the accused. He had not retaliated in any manner. He has not given them any permission to enter. The only credible piece of evidence is that his version is corroborated by Exhibit 3 and a portion of Staff Sergeant Gilbert Mapisa's evidence. The state indicated that the court should accept the evidence of the witness because there is no material contradictions in his evidence and that his evidence is being corroborated by Exhibit 3 and that of Gilbert Mapisa concerning the assault. The defense rebutted this view and argued that These contradictions cannot be assessed in isolation of the version of the accused in respect of their defense or justification, and that it is indeed material. The following terms of the version of his version is established. He made 4 statements which has given rise to discrepancies, and the state replied that these discrepancies is not material. These contradictions is greatly in respect of the fact surrounding the issue of his statement and his oral evidence that address the issue of entry as a person or a vehicle, had to have a permit and being part of a convoy. He did not see a visible permit, or someone may have put it there later to something resemble of a reflection that may be there, whether they were given permission to enter or not. His evidence was not impressive when he tried to explain the discrepancies under cross-examination. Objectively, he has not conceded anything favorable to the defense, even if it is clear that he had no grounds other than to concede. For example, in his statement, he creates the impression that they, as a person, are not allowed to enter, and then he wants to justify it as meant to say they should be interpreted as a vehicle. State argued that I should be mindful that not all discrepancies in statement caused by one sentence could be interpreted in one or two ways. Must be read in context of the whole statement, handle different versions of the same witness with circumspection. Secondly, that not all discrepancies affect the credibility of the witness. However, Colonel Venter is a senior police officer with 36 years of experience. Which 6 of those years was within the South African Police Services Presidential Protection Services, head office in Pretoria. He is not a normal police officer, or a constable, or a lame person in this regard. In fact, he have made 4 statements and was also assisted by his union, which refer him to Herter and Spies, who in turn refer him to every forum. It was important for him to testify about the reason he stopped the accused's vehicle, but also so many attempts and years have gone by. He still creates different impressions of why he stopped them. One of these impressions is in line with the version of the accused, that for all these years they were under the impression that they were not allowed entry as a person. When assessing the discrepancies in its context, I cannot proceed, even if it means I proceed long end. I also am aware that the court have granted the media access to record as well, but they should also be prepared for load shedding in this regard. So I am going to proceed with the matter, whether they are recording or not in this regard, but the matter needs to come to a finality. I'll just restart from the last sentence. That for all these years, they were under the impression that they were not allowed entry as a person. When assessing the discrepancies, it is in its context. I cannot attach any other meaning that this is a discrepancy or contradiction when read it in totality. It don't make sense, and it does affect credibility of the witness. He should know why he stopped them and why he refused entry. This case is going on for years, and yes, I do acknowledge the reason why a statement is being made in the first instance and what may give rise to errors in a statement, such as language, various cultural differences between the witnesses and the person who took down the statement, and the fact that no explanation is required when taken down the statement. But 4 statements, same errors, says a lot. Now, ultimately, this is what the state wants the court to believe. The statement versus the oral evidence should not be inferred out of context, but assessed in a whole. So the time the witness made the first statement, when memory was better reserved, is actually secondary to the oral evidence which is given years later in the whole context. I must accept that in spite of these contradictions, it has no effect on credibility. I disagree with this view and found that the discrepancies does have an effect on credibility. After mentioning this, I am further aware that not all contradictions and discrepancies is material. For it to be relevant, it must have an effect on the definitional elements of the offense. It may be viewed, as the state indicated, that it is irrelevant, and the defense, as per their heads of argument, that the discrepancies is material. These discrepancies goes to the heart of the right to enter and has a bearing on the accuser's version of justification. I will deal with that later on, because whether it is relevant or irrelevant, it will depend on what test the court has applied for the grounds of justification. 37. In the assessment of Colonel Venter's evidence, I come to the following conclusion, which is argued by the state and the defense. There was an assault by way of pushing on Colonel Venter caused by the accused acting in unison. The injuries was sustained. No injuries was sustained, just mild pain. This assault occurred because the accused believed they acted in justification. The accused lacked mens rea. Therefore, I consider his evidence. After I considered his evidence in respect of the assault, and that it has being corroborated by the video footage, and to certain extent Staff Sergeant Mapisa's evidence, who has witnessed the pushing of the complainant, I found that the discrepancies in both versions is material. It will refer to the accuser's version of justification. It leads to the assessment of their version, what their state of mind was when they were refused entry. This will be taken further as well when I deal with the application of the law itself. 38. The evaluation of the evidence of Gilbert Mapisa. The court remarks as follows. The impression created by this witness is that he has worked at a lot of state funerals as a military police officer, and after the 3 years of experience as a staff sergeant, he knows the procedure that must be applied. On the 14th of April 2018, he stopped the vehicle of the accused because they were not part of the convoy. He let them pass because of VIP status. However, in his evidence, there is 2 versions created, and both cannot be true. I quote, I confirm that the vehicle that were having escort were directed straight to VIP parking, including the black Vito, which was transporting the EFF members. The state indicated that the court should accept the evidence of the state witness because there is no material discrepancy, and that he maintained under cross-examination that the black Vito was not part of the convoy. The defense rebutted this view and argued that these contradictions cannot be assessed in isolation of the version of the accused in respect of their defense of justification, and that it is indeed material. Once again, I am requested to accept that the oral evidence that the accused is not part of the convoy is more probable than the statement which was made when the event should have still be fresh in his memory. This means that the witness in this regard has contradicted himself, and the one version also contradicts the complainant. His version must also be further assessed in light of the accuser's version with the raised defense of justification. I have already indicated in the Section 174 application that I believe that the state failed to prove that the accused was not part of the convoy and refrained from making a finding on credibility. Now that all the evidence has been placed before the court will make a credibility finding at the conclusion of the case, of the ruling. After the evaluation of the state witnesses, it is a matter of logic that the prosecution evidence does not need to be rejected in order to conclude that there is a reasonable possibility that the accused might be innocent. What is required in order to reach that conclusion is at least an equivalent possibility that the incriminating evidence might not be true. Evidence that incriminates the accused and evidence that exonerates him cannot both be true. There is not even a possibility that both might be true. The one is possible true only if there is an equivalent possibility that the other is untrue. In the case of S. v. Stevens, it was held that a court should not follow what has been called a compartmentalized approach to assess the evidence, namely which divorces the evidence before the court into compartments by examining the state's case in isolation of the defense case. This view has also been confirmed in the Supreme Court of Appeal. It would refer to the State versus Naidu and others, which is under a footnote. 41. The totality of the evidence must be considered, and therefore the court must evaluate the accuser's version as well. The court considered 42. The court considered the evidence of the defense and remarked as follows on Mr. Malema and Mr. Ndlozi's evidence. The defense addressed the court, and their version should be accepted because of the following reasons. They have successfully raised the defense of justification. Their version was concise, and they did not crack during cross-examination. They did not hesitate to give answers. Their oral evidence and plea explanation is precise. They stood by their version and did not deviate in any manner. They successfully proved that they were acting in justification. The prosecutor addressed the court at the accuser's version should be rejected because the accused version, or the court will just rephrase, the accused when assaulting the complainant acted in unison. The discrepancies must be assessed in context, and it is not material to the evidence of assault. That there is no version which was put to the complainant that they did not assault him. The accused did not act in necessity, that the defense of justification should be dismissed. The accused, when giving their evidence, was not elusive to questions and did not hesitate in answering any questions. They have not contradicted themselves or created different versions before the court. I cannot also find any improbabilities in their evidence. On this basis, I have not assessed their evidence separately, as their versions is similar in nature and they have no contradictions on one another. They have also given court a detailed explanation as well as in the time collapse which was caused by them being stopped by the complainant that the court should not infer that they were late or have forced their way into the convoy. 43. The applicable law, common purpose, the doctrine of common purpose, complicity, secondary participation, common design or joint enterprise refers to the situation where two or more people embark on a course of action with a common purpose resulting in the commission of a crime. In this situation, the participants are jointly liable for all the results from the act and omissions occurring within the scope of their agreement. Thus, each of the parties to an agreement or understanding is guilty of any crime falling within the scope of the common purpose which is committed in carrying out that purpose. Therefore, I am in agreement with the cases of S versus Magesi, S versus Tibius, and other S versus Toby. It goes without saying common purpose between state and it is common purpose between the state and the defense, that common purpose is applicable and that both accused have acted in unison. 44. I have been referred to different approaches by the state and the defense towards the evidence which is before the court. The state indicated that the court must assess the ground of justification to be necessity and that the defense as putative private defense must also to be considered. Therefore, a cardinal principle of criminal law is embodied in the maximus actus non facet reum nisi mens sed rea. An act does not make a person legally guilty unless the mind is legally blameworthy. Necessity. Definition: act in necessity if he acts to protect his or somebody else's life, physical integrity, property, or other legal recognized interests endangered by a threat of harm which has begun or is immediately threatening, on which cannot be averted in any other way, provided X is not legally compelled to endure the danger and the interest protected is not out of proportion to the interest threatened. Requirements for the defense or for the plea of necessity: a legal interest must be threatened. May protect another. Emergency begun, not yet ended. X can rely on the defense if he caused the emergency. X must not be legally compelled to endure danger. It must be the only way to avert the danger. X must be concise and emergency exists. Not be harm caused or not be more harmful caused than what is necessary. Defense of necessity and private defense is almost similar but differs in material aspects. The difference between the defense of necessity: in both cases, act protects certain interests, life, physical integrity, and property against danger. The difference between origin of the attack: defense from an unlawful human attack, necessity from an unlawful human attack or circumstances as a natural occurrence. Objective at which the defense directed: defense an unlawful human attack, necessity, interest of an innocent third party or violation of a legal provision. Examples of an act of necessity: a ship sinks in a gale and 3 survivors cling to some driftwood. A 4th survivor attempts to hold on to the driftwood but is pushed off and drowns. The emergency was an act of nature and the defense was directed at an innocent person. Now dealing with putative crimes. Putative crimes is a type of crime which does not exist, but which X believes to exist. This exception, putative crimes, operates if X is mistaken about the existence of a crime or a legal nature of one or more of its definitional elements. Now, to be more specific, the defense refer me to putative private defense. This is then with the case of S versus Tutor, which the court have indicated should not be read into record. This, of course, is not a true form of private defense. It is usually stated that the test for private defense is objective. This proposition is acceptable, provided that the role of this objective test is merely to distinguish between actual private defense and putative private defense. Burchell argues there is no absolute duty to retreat from an unlawful attack. The issue of whether the victim could or should have retreated is merely one of many issues to consider. It is also important to look at the following factors. Unlawfulness. Unlawfulness means contrary to the community perception of justice or legal convictions of the community. The Bill of Rights in Chapter 2 of the Constitution must obviously play a role in deciding whether a conduct is in conflict with the public policy or the community perceptions of justice. The values reflected in the Constitution, such as human dignity, the achievement of equality, and the advancement of human rights and freedom, are of crucial importance in deciding these issues. Therefore, in deciding whether a conduct is unlawful or not is the legal convictions and not moral convictions. In dealing with the defense, submissions of an example that X actions is at first glance seems to be unlawful in damaging a road and rebuild it to maintain a business, and therefore due to legal convictions of the community perceptions of justice, her actions may be deemed lawfully. The court is well aware that this comes out of Snyman under the heading also with dealing under unlawfulness. This is also then an assault case. In assaulting someone because he refused to grant you entry can never cause more benefit to society than the actual harm that was done. So we cannot directly compare assault with malicious injury to property. Sometimes it will be interpreted lawful, unlawful, but the mere fact in this instance is to the extent that the community will never condone that you may assault somebody just because he does not grant you entry in this regard. The test for unlawfulness, it is sometimes alleged in South Africa, legal literature, that the test to determine unlawfulness is objective. This view is incorrect, and the test should compromise both objective and subjective factors. So when one looks at unlawfulness and culpability, the following may be said. Unlawfulness may be described as a judgment or an evaluation of the act, and culpability as the judgment or evaluation of the perpetrator. Culpability then. In legal literature, especially the older literature, as well as the terminology used by the courts, this element is described by the Latin expression of mens rea. Culpability consists of two compartments: criminal capacity in the form of intent and negligent. I will only deal with the form of intent, since this required form of culpability is for the crime of assault. There is no negligent assaulting of another person. This offense can only be incurred by the necessary intent to act according to your will to cause injury to another person. A person commits an act while his will is directed towards the commission of the act or the cause of the result, in the knowledge of the existence of the circumstance mentioned in the definitional element of the relevant crime and the knowledge of the unlawfulness of the act. Compliance with the definitional elements of the unlawful act does not necessarily demonstrate that the person is criminal liability. Additionally to the person must be culpable, have mens rea. Example, he must be personally blameworthy. Criminal capacity connotes that the person must have the ability to appreciate the wrongfulness of his action, cognitive knowledge, and to act in accordance with such appreciation. in brackets, cognitive limp, self-control. Moreover, the Act must be supplemented by the prerequisite intention or negligence. It is clear from the application of mens rea in the court that it has nothing necessary to do with notions of an evil mind, moral fault, or knowledge of the wrongfulness of the act. It is generally also irrelevant that an accused acted with a good or a bad motive. The following authorities has been taken into account as referred to by the state, and the citation is as per the heads of arguments. I do not find it necessary to read. For purposes of the electricity that went out, the court have listed all the authorities such as S versus Tibius, which the state have referred me, and I do assure the court has taken all these cases into consideration. All these cases refer then the court that needs, all these cases refer to what needs to be proved in the requirements with reference to the unlawfulness, real evidence, corroborations, and ultimately the discrepancies, and as well as common purpose, as the state have indicated. The defense has also referred the court to the following cases cited as per their heads of arguments, S versus Trainer, and all of other cases as well. But for this record purposes, I believe the most important case which is to be considered is the defense case of S versus Tutor, which they have attached to the heads of arguments, and I believe that is the reason why the full case has been also placed before the court. Now 46, or just before 46, as indicated, all these cases which the defense have referred the court to will deal with private, putative, private defense, the assessment of evidence, intention, cross-examination, onus rests on the state and not accused, and when the court has to draw an inference from the facts which was placed before it. I am aware that judicial remarks on factual issues, irrespective of the universal nature of the language used to express them, are not principles, even less do they constitute binding precedent. At best, they are useful analogs, indicators of what was done in comparable cases. So all these cases which the court was referred to by the defense and the state, I cannot just simply say that because in those cases certain findings was made, so that findings will then be applicable to the accused. But those are just merely guidelines for the court to come to a just conclusion. So 46, conclusion. 47, in deciding whether there is political agenda between the state, every forum, and the National Prosecuting Authority, I found that the only reference to this is in the accuser's plea explanation, and particularly in Mr. Malema's evidence and cross-examination. There is, however, no supporting evidence to that effect or a substantial basis for the accusation, and it cannot be upheld, nor may I draw an inference that there is a reasonable possibility that it may be true. This point was also not substantiated, relied on by either party in their heads of arguments before the court. It therefore appears that the crux of the case is whether the accused acted intentionally without any grounds of justification when they assaulted the complainant. 48. South Africa is also a very unique country, and embedded in our history is the adoption of peace and reconciliation. Therefore, to settle less serious matters through a process of mediation, it's well accepted in our legal system, and it affords the state and the defense an opportunity to reach an amicable solution between the accused and the complainant. Therefore, Exhibit E is an indication of the outreach of such a process which have failed. The court is not involved in such processes. The state is dominus litis, and the power to withdraw a charge is solely vested in their discretion. Since it has failed, it is not necessary to attach any weight on Exhibit E, as well as the principle of Ubuntu, because of the broken down process between the parties. 49, Exhibit A, which is the funeral program of the late Miss Winnie Mandela, and it is clear that such a program was not received by any of the state witnesses, and even as Mr. Gilbert Mapisa indicated that it was an auspicious event. This is proof that Mr. Malema has played a vital role in terms of the burial process, and it is supported by his version that he was entitled to be at the cemetery. It also goes to the crux of the state of his mind. The test for intention is subjective. The court must determine what the state of mind of the particular person is. As I have indicated that I would deal with the issues of discrepancies in the state of the state witnesses, evidence which relate to the issue of the statement, and oral evidence. Firstly, the statement creates the impression that the accused was denied access into Memorial Park Cemetery for the burial of the late Miss Winnie Mandela. Secondly, it creates the impression that they were stopped even if they were part of the convoy. Lastly, the version under cross-examination went from nobody other than the family and the president were allowed to enter in the vehicles, only accredited vehicles with permits could enter, the accused vehicle had no escort, accused vehicle was not part of the convoy. Even if the vehicle had a permit, he would not allow it to enter. He contacted VOC to get permission to allow them entry, and General Zulu did and did not give permission. This is, however, not mentioned to determine whether the accused had a right to enter with the vehicle or not, since I have dealt with this issue of entry in the Section 174 application. This is now mentioning in light of credibility, which the court still has to deal with. I found that the discrepancies have created a belief in the mind of the accused that their right to freedom of movement and to dignity is being infringed upon, which right is being fully protected by our Constitution. This can also not be placed in a comparison of what have transpired prior the convoy arrived. Those people was not part of the people who attended the funeral of the late Miss Winnie Mandela. It was also being dealt with by Ms. Erasmus, a person of the administration section of Memorial Park Cemetery, who is not the senior of Colonel Venter. Those people were more acceptable to understand that the cemetery was closed for a state funeral and it did not affect their rights to have closure or to bury a loved one in dignity. In terms of the two ladies, they were not prevented entry but informed to wait until the family has arrived. The court will just repeat that sentence. The two ladies were basically informed. They were not prevented to enter but informed to wait until the family has entered. So no impression was created that they are not allowed to enter as in the circumstances of the accused. Therefore, in comparison with the accused, who was part of the people who attended the funeral, and Mr. Malema, who played a vital role as per the funeral program at the stadium, that this submission that there was an alternative method to deal with the issues of entry cannot be upheld nor have any weight nor any basis. I understand the state submission saying that these issues could have been dealt with differently, but not all people act in the same manner when faced with a threat or danger. In approaching the matter to say that because the 5 people was being dealt with in a certain way, and that the accused could have spoken to the senior of the complainant to gain entry peacefully would be to apply an objective test without considering the subjective approach as per the case of S versus Tutor. In this case, the applicant was convicted of murder and later on appeal released on the grounds that the court has applied the wrong test in assessing the ground of justification. The facts is shortly that the applicant stabbed 2 police officers who was chasing him, whereby one died and the other one critically injured. He was convicted of murder and attempted murder. His defense was that he believed that the people who chased him wanted to rob him. He has informed his sister after the incident, and also the next day went to report the incident at the police station and was then arrested. On appeal, the court found that the subjective test should be applied to determine whether the ground of putative private defense exists. The state of mind of the applicant at the time of the incident should therefore be considered. Now, looking at intention, irrespective of unlawfulness, the accused must also have the intent to accomplish the definitional elements of the offense of assault, knowing that the conduct is unlawful, or he must foresee the possibility of his conduct comply with the definitional elements of the offense of assault, and therefore being unlawful, but nevertheless proceed with it. Differently put, he must know or foresee that the type of action in which he is engaging in is criminally punishable. This brings us to the point in the state submission and the defense reply thereto that no version from either accused was put to the complainant during their testimony. The submission by the defense is that no version was put to the accused and that their version was not seriously challenged. To be realistic, one must look at the whole of the evidence, including the plea explanation. When a person says, "I act on the ground of justification," then literally he confirms his actions. In this case, the actions refers to the pushing of the complainant. Therefore, it is also not dispute. Therefore, there is no dispute with regards to Exhibit 3. All this evidence is common cause between the state and the defense. It is right law that the test for intention is subjective. So how does the state prove intention? They may do so by way of direct evidence or indirect evidence. One must also take into account that the accused is under no obligation to give evidence or to prove his innocence. In this case, they confirm the act of pushing the accused under the belief of justification and to exclude any intent of assault the complainant. The version of the complainant affirms that he was assaulted by way of pushing, which is confirmed by the video footage and Mr. Gilbert Mapisa's evidence that he saw people pushing each other. Looking at this with the version of the accused, he pushed him and keep on pushing him to make sure that he does not return to stand in front of the vehicle and block it from going in. Our intent was not to assault the complainant, but we wanted to enter the cemetery to pay our last respects to the late Ms. Winnie Mandela, and above all, to get closure. As we then pushed him out of the way so that the vehicle may enter. If I also look at the indirect proof of intent, the court must then guard against applying an objective test instead of a subjective test. It is dangerous to argue as per follows. Any normal person who commits an act which the accused have committed would know that it would result in the assault of the complainant. Therefore, the accused acted intentionally. Although I am free to apply general knowledge of human behavior and the motivation of such behavior, I know that I know that I must guard against exclusive considering what a normal, ordinary, or reasonable person would have thought or felt in the given circumstances. I should go further than this and must consider all circumstances of the case. I have to place myself in the position of the accused at the time of the commission of the offense to establish the state of mind of the accused at the moment. For this reason, the state referral to the 5 other incidents cannot be accepted as already indicated. Also, that the state of mind must be inferred from the whole of the evidence. I cannot infer from that whole of the evidence because the inference seek to be drawn is also not consistent with all proven facts of the case. And therefore, it must exclude all reasonable inferences. I accept the one that is seek to be drawn. Therefore, the version of the accused, as I already alluded to, the discrepancies by the state witnesses creates an impression that they are refused entry as a person and will not be part of the mourners of at the cemetery, which in turn have led to their actions. This version stands, and it was not challenged or contradicted in any way. Their intent to remove the complainant to gain entry is also reasonably possibly true. The court also looked at the whole merits of the case, which is before me. In the case of S versus Souls, the judgment illustrates the dangers of what has been called compartmentalized approach in the assessment of evidence, an approach which separates the evidence before the court into compartments by examining the defense case in isolation from the state's case and vice versa. What must be borne in mind is that the conclusion which is reached, whether to convict or to acquit, must account for all evidence. Some of the evidence may be found to be false, some of it may be found to be unreliable, but none may simply be ignored. Then when looking at the version of the accused, the court does not have to be convinced that every detail of the accused's version is true. If the accused's version is reasonably possibly true, in substance, the court must decide the matter on the acceptance of that version. Of course, it is permissible to test the accused version against the inherent probabilities, but it cannot be rejected merely because it is improbable. It can only be rejected on the basis of inherent improbabilities. If it can be said that the version is so improbable that it cannot be reasonably possibly true. I would also like to refer to the case of S versus Souls once again at paragraph 180, E to G. There is no rule of thumb or formula to apply when it comes to the consideration of the evidence of a witness. The trial judge will weigh its evidence, consider its merits and demerits, or having done so, will decide whether there are any shortcomings or defects or contradictions in his testimony to determine whether he is satisfied that the truth has been told. When there is a conflict of fact between the evidence of the state and that of the accused, the proper approach in the case such as that is for the court to apply its mind not only to the merits and demerits of the case, but also to the probabilities. So one must take into account the state's case has discrepancies, which in turn affects the mindset of the accused. There were mourners on the day in question. They have not planned to be stopped by Colonel Johannes Venter. Since the roads to the cemetery was closed and it is, as per the evidence as a whole, impossible to join the convoy, it can then only be, as I have already indicated in the Section 174 application, that the accused had a right to be there. I also accept that the accused was not late for the funeral on that day, that they were also behind the BMW X5s depicted on Exhibit 3, and that the delay in the time was caused by the fact that they were stopped by Colonel Johannes Venter. That version and explanation is reasonable and probable in light of the discrepancies. The erroneous belief in the existence of a ground of justification also, the conduct remains therefore unlawful as well. Subjective factors must be considered in deciding whether an act is lawful or not. However, just as it is wrong to say unlawful is consisting of merely objective external factors, it is similarly wrong to place all emphasis on subjective factors and to forget about the objective ones. No grounds of justification can exist in the absence of objective factors, and for this reason the accused conduct then remains unlawful. If they subjectively thinks that there is a ground of justification, whereas in fact there is none. A so-called putative ground of justification is therefore in fact no ground of justification. A putative ground for justification is one that does not legally exist, but which the accused believe to exist. It exists only in the imagination of the accused. They mistakenly believe that their conduct is covered by a ground of justification. This in turn, when one assesses the state's evidence, it will lead the state to believe that the accused is relying on a ground of necessity. I agree with the state. They did not act in necessity and that the ground of justification cannot be upheld with regards to necessity. Even when I agree that the accused did not act in necessity, one should also clearly understand the evidence is in its totality form. The accused indication that they both believe that they were entitled to enter the cemetery and their obstruction is unjustified. In these circumstances, they lack mens rea because they believe that they were entitled to enter. So they believe that they have acted on a ground of justification to gain entry. In this regard, the court cannot ignore the defense submission based on the evidence before the court, and that both accused believe that they have acted in putative private defense as well. Irrespective of necessity in putative private defense, it is clear that the test for intention, which is the definitional element of the offense of assault, and for putative private defense is subjective. As alluded above, the accused had reason to believe that they acted on a ground of justification, putative private defense. Their version with regards to the intention is clear, as I see no reason not to accept it in light of the discrepancies of the complainant's evidence. This leads the court then to the crux of the state submission, where the defense of justification is a valid defense based on the evidence on the record. This is a question which the court must also answer on the basis of the evidence in its totality. It is right law that there are different types of grounds of justification. Some well-known grounds of justification is private defense, necessity, consent, and official capacity. Defense specifically also referred the court to consider putative private defense. Now, based on all the principles in law concerning justification, it is clear that the court should apply a subjective test and establish the state of mind of the accused at the time of the committal of the offense. In terms of putative defense, the act will remain unlawful, but it will exclude culpability. In this regard, I found that the state of mind of the accused above mentioned and thus effect culpability. Court's finding, I do then find that the action of the accused at first glance appears to be unlawful, but after carefully assessing the evidence, one can never assault any other human being than in gain of an entry. The evidence in its totality also confirms the version of the accused before court. The accused further lack intent to commit the offense of assault in this regard. In this regard, the court finds that even when the court carefully assess the version of the accused, the court finds that the accused version is reasonably possibly true. Therefore, I accept that the defense of justification is to be upheld and that the accused had no intent to assault the complainant based on the evidence which is listed above, based on the reasons which is listed above. Both accused is therefore found not guilty and acquitted of the charge of assault. Judgment is dated for 29th of February. The court have prepared the court once ordered. The court have also, as indicated, I do not believe the machines are working at this stage. I have then also prepared copies of the written judgment of court for purposes of both parties. Ms. Hart, you may just approach. The court judgment is also then being listed in marked as Exhibit S. Is the court book available?
No, Your Worship. The court 13 sitting in another court, Your Worship.
Court 13. It may then be brought. The court. Ms. Hart, the charge sheet and such must be collected from Mr. Reddy's office. Mr. Reddy.
Mr. Reddy's
Office, yes. Thank you. Court adjourned.
Oh, yes.
Well done, guys. You know, I wrote it for my children. What is fugitive private defense?
Right.